Good afternoon, lawyers. Welcome to the Appellate Division First Department. We have almost 7 hours of oral argument time requested. You've heard the spiel. Ask for the time that you need, not the time that you want. Hopefully, we'll make it by 9 o'clock when Aaron Judge hits his 61st home run, right? I'll begin with the call of the calendar. People versus Dufresne. Okay, submitted. Nakamura versus motor vehicle accident. Tell me how much time do you want, counsel? We're really going to need this much time on one issue? I tell you what, I'll give it to you. You're not going to need it, I can guarantee you. Then we have S. Arian versus Jose R. and Jose R. versus Arian S. and they both submitted. Lee versus Lafer. Please keep your voices up so that I can hear you. Let me hear from Appellant and Lafer first.
Ready for the appellant, 4 and 1 rebuttal.
4 and 1. Respondent Lee. 4 and 1 and 5. Pierce versus City of New York.
Respondent requests 7 minutes.
Okay, I'll do 6 and 2 and 6. If you folks remember, there's no clock for us. If we have more questions, we'll just keep asking, okay? More likely than not, that case is not going to go that long. People versus Guzman. I cannot hear you. 1, 2, and 4. Bugling versus Naicha. Respondent Naicha. Anybody for appellant? Do you wish to submit?
Unless the panel has any questions, I'll submit.
Folks, I think we're good. Thank you so much. I'll mark it submitted. Franklin versus Shallow River.
Defendants, appellants, 5 and 2. Respondent Franklin, 4 minutes, no less.
5 and 2.
Respondent.
And 5 and 2 and 4. The other?
Respondent, the others are on 4 minutes.
Okay. Then we have People versus Raymond Rivera. Okay, on both cases, right? Okay. So 5 and 2 on both cases for Rivera. People? And 4. Ellison Seltzer is submitted. People versus Gonzalez. That's submitted. People versus Burgess.
For Mr. Burgess, 3 and 1, please.
3 and 1. People. 3 and 1 and 3. MNC New York versus Accor Management. Okay, so I'll tell you what, I'll do 7 and 4 and 7. Kasowitz Benson.
For the appellant, Your Honor, I would request 10 and 2, please.
Respondent, 10 minutes, please.
Okay, that case is going to be called first, so I understand there were going to be some demonstrative evidence, so get it ready at the end, because you're batting up first. Zurich American? I can't hear you. 6 and 2 for Zurich. Ace American? The others, right?
Appellant Scottsdale requests 2 minutes as the appellant 5 minutes of response.
Scottsdale, hold on. 2. And 7.
Your Honor, responding RSUI requests 3 minutes.
Then 3. Okay, that adds up. People versus Smith is submitted. Marie Holdings versus Bicycling Court.
The appellant requests 5 and 3.
5 and 3 for Bicycling Marie Holdings. What was it? I'll give you 6. Gunn versus Hamilton. Okay. 8 and 2 and 8. Harlem Contracting versus Whittingham is submitted. Sutton Lennox is submitted. TGT versus Advanced Entertainment is submitted. As I mentioned, Castlewitz Benson versus JP Morgan Chase is going to be called first, so please come up. Justice Weber and Justice Moulton will be recused, and Justice Salian Scarpula is being vouched in. Okay, Castlewitz. Okay, when you're ready, counsel.
Thank you, Your Honors. May it please the court, my name is Zachary Newman on behalf of appellant JP Morgan Chase Bank. There are 3 reasons this court, upon its de novo review of the proprietary lease at issue, should reverse the lower court's decision and judgment. First, the plain language of the legal fee recovery provision requires a tenant default for the landlord to recover its legal fee.
Aren't you engaging in a collateral attack on the Dakota judgment by focusing on the provisions of the lease? You never objected to the lease before, right?
No,
I'm
Your Honor.
missing something.
My apologies, Your Honor. No, it is not a collateral attack on the Bluth judgment. That was only an action between the Dakota and Mr. Fletcher.
But what?
But it wasn't it for Mr. Fletcher to raise it at that time?
No, Your
Or for
Honor.
you to seek permission to intervene in that action?
No, Your Honor. No.
Tell me what.
Let's assume you're correct. What impact would our agreeing with your position that the provision at issue requires a default, what impact would that have on the judgment itself today?
It has an impact with respect to its enforceability against JP Morgan Chase's assignee.
But you destroy the judgment, correct?
No,
The
Your
judgment
Honor.
is a nullity.
No, that is for Mr. Fletcher to raise. That wasn't raised, frankly, when you look at the record in the Fletcher versus Dakota lawsuit. But vis-a-vis Chase's rights as an assignee, as a lender, that judgment has no force and effect.
So you're saying the judgment is effective, their judgment is good and not good at the same time? Have you ever seen a judgment that's good against some people and not good against some people?
Well, Your Honor, when you look at that record, which Chase was...
Let me just ask you, isn't that your position, that we should enforce the judgment against some but not others? Have you ever seen a case where a court said a judgment is partially good and partially not good?
That's not our position, Your Honor. And what we're saying is the judgment is not enforceable against Chase as an
Well,
assignee.
you can use the words, whatever words you want to use, but you are saying that the judgment is not good
As to
against
you.
As to Chase as an assignee, that's right.
But it's good
Dakota-
as to some other people.
That's actually not our concern, Your Honor. And
It's not your concern, but it's the reality of it. If we vacate the judgment as against you, the judgment is vacated. So the judgment is a nullity.
I mean, with all due respect, there is no judgment against Chase. Chase was not a party to that case. This case came after Chase's assignment of the lease under Gramerton. The Court of Appeals case makes it very clear that a judgment against the assignor cannot bind the assignee. The Dakota had every ability, if it wanted to try to bind Chase to that finding, to have named Chase in that lawsuit. This is why Justice Kalish, when
Well,
raised
they bound Mr. Fletcher, right?
If you look at the pleading in the record, if you look at the pleading in which Mr. Fletcher brought the case against the Dakota, and
you take as his assignee, right?
yes,
So you take whatever he had and whatever he doesn't have. You don't get more or less. So if the judgment is good as against him, why is it not good as against you as his assignee?
because under the Gramerton case, the Court of Appeals case addressed this very issue, and it said if the assignment occurs before the judgment, the assignee is not bound. We are not in privity at that point. We are not bound by that judgment. We have every right to say when they do come forward with...
Fair enough. So you go back to the trial court and you say, here are my defenses to this judgment, right? I've never seen a case where you say, don't enforce a good judgment against me, because that's not an appropriate way to challenge the enforceability of the judgment. The only way you could do it is to go back to Supreme Court and step into the shoes of the debtor, the judgment debtor, and say, I'm not bound by this judgment. Here are my defenses to it, right?
Your Honor should be very concerned about how that judgment was obtained, and with respect to the claim by the Dakota to seek legal fees, not with respect to the legal fees that were sought with respect to violations of equal rights statutes that were asserted in that case. But Justice Kalish was presented with this very issue, Your Honors. And Justice Kalish, when he was presented with a protective order motion by the Dakota, where the Dakota came into court and said, Chase should not receive any discovery, should not receive any depositions, because we have this judgment for attorney's fees. And Justice Kalish said, no, no, no. I hear the privity issue, and I raised the point in court to Justice Kalish. How is this court dealing with the privity issue and the enforceability of that judgment? And Justice Kalish, I submit to Your Honors, rightly said, I'm not going to be concerned about the amount, because the reasonableness of those fees were determined, but whether it could be assessed against you, Chase, under this lease is something I will consider. And that is something that Justice Lubell in the lower court did not consider. And where we have an assignment that predates the lease and you have a landlord that is looking to assess legal fees against Mr. Fletcher and then by virtue...
It's not a landlord, right? It's a co-op board that has a security interest on the shares in questions to that apartment, right?
It is a landlord. There is a lease. There is a lease. It is a landlord-tenant relationship.
Right, there's a
Absolutely.
lease, there's a lease to which there's a time to challenge, right? You can't challenge the validity of the lease to which you were not a party, right?
But-
You have to rely again, as Justice Carpula mentioned, on the rights that were asserted or not asserted by Mr. Fletcher.
JP Morgan Chase comes forward and says, do you have this right to charge this under the lease and against me? You, the Dakota, signed a recognition agreement whereby you recognize our rights as a lender, as an assignee. And when you look at this clause that's before your honors, and you look at the explanatory comment that went to the tenant shareholders with the clause, it's absolutely
Why should
apparent.
we, counsel, why should we even consider that comment in light of the plain language of the provision?
For a number of reasons, Your Honor. First, the court is absolutely empowered to look at the context and circumstances of the contract signing in order to ascertain the intent of the parties. This explanatory comment actually is consistent with Chase's interpretation and read of the provision. So we submit, Your Honor, that Justice Lubell, who did...
Doesn't that assume that there is some sort of ambiguity in the provision?
No, Your Honor. The court can look to context and circumstance. But, Your Honor, where Justice Lubell was presented with two interpretations, may I finish, Your Honor?
You go ahead.
I see my time is
Go
up.
ahead.
Where Justice Lubell was presented with two interpretations, we submit that he made clear error where a clause is reasonably susceptible to more than one interpretation.
But it isn't. He found that it was clear and unambiguous.
With one sentence, and he was wrong, Your Honor, because Chase came forward not only with its own interpretation that matches the grammar of the provision, because the Dakota's read completely eradicates that first comma after the modifier, the tenant has to be in default. But if you look at the explanatory comment, it specifically says that if litigation is commenced against the Dakota by an individual tenant, that the fees can only be recovered if there's a default. So the explanatory comment is not used to demonstrate an ambiguity. Chase came forward with a reasonable interpretation. It's not for the trial court to say, I like that interpretation over that. So where the ambiguity is then presented, Your Honors, putting aside context and circumstance, you then go to extrinsic evidence. Justice Lubell doesn't even consider the explanatory comment. This is an admission by the Dakota board as to what they intended. They never intended, look at the last line, to protect an individual tenant. Our ability to recover such expenses is limited to those instances when the tenant is actually in default. And in closing, Your Honors, the Dakota's interpretation, where they say any tenant commenced action entitles us to recover our legal fees, absolutely violates this court's ruling in Crodell. It allows a landlord, a co-op landlord, a residential landlord to impose its legal fees no matter what, under every circumstance whatsoever. It's violative of public policy, and it should be invalidated.
Why isn't Crodell distinguishable?
Crodell is not distinguishable because Crodell says anytime that you have a fee provision in which the landlord can still recover its legal fees for its default or otherwise, it's an unfair provision.
But counsel, in that case, it was with respect to the landlord's own default. Those aren't the circumstances here, correct?
But it's not outcome determinative. It's the dissuasive effect of the provision. And that's why in the 1885 case by Justice Kahn said that here we have a provision that doesn't specifically say landlord default, but it allows the landlord to recover no matter what. That fits within the confines of the Crodell holding. And that we're not going to allow landlords to do. We're not going to give the landlord the ability to impose its legal fees. And Your Honor, if I could just give you a very, very quick example.
I've given you a lot of time, counsel.
May I just give you this one example?
I'll give you 30 seconds and then let me hear from respondent. Got a
Thank you, Your
long
Honor.
calendar.
So the lease provides the landlord's not responsible for damage if it breaks and enters into an apartment, except for its own negligence. So it gets reports of a water leak, it goes into the wrong apartment, it causes $200,000 worth of damage. Case goes to trial, the tenant shareholder wins, gets a judgment for $200,000. The Dakota turns around under its interpretation, which this court has invalidated under Cordell, and says, I incurred $300,000 of legal fees, and I get to offset your damage award. It's an absurd result when you look at the
Counsel, you know,
balance.
that's an interesting example, but that's really not the fact pattern here.
Right.
Correct?
Right.
It's not the fact pattern here, but you had a racial discrimination case.
It's apples and oranges.
I respectfully disagree because this is a racial discrimination case where the Dakota incurred an exorbitant amount of fees and are looking to prime the lender. And the lender is merely saying, is this recoverable as additional rent under the lease agreement? And Chase respectfully submits that it is not.
Okay.
And it's
Thank
the
you, counsel.
Dakota's own words that show it.
Thank you, counsel.
Good afternoon, Your Honors. John Vandertine for Respondent, the Dakota. And I think Your Honor's questions have highlighted our principal position here, which is that even if my colleague here were correct that Justice Bluth misinterpreted or misapplied the lease, and we suggest that she did not, and we're happy to show that she did not, even if that were so, this is not the court, the time, or the place to collaterally attack that final judgment. Chase had ample opportunity to assert its interests. It was on full notice 2 years before.
I mean, Chase was not a party to that litigation, right?
You're correct, Justice Acosta. They were not a party, but they were a privy under the law. As my colleague has repeatedly said here, they were the assignee of the party, Fletcher, to that case.
And did they get notice of the default and the hearing on the default?
They did, they did.
And so they could have gone at that hearing and made the arguments that they are making on appeal now, correct?
Absolutely. In fact,
Before the judgment was entered, to talk about the judgment, whether or not the judgment was properly entered, right?
you're quite right, Justice Scarpula. We gave them a copy of our motion papers on the fee application 4 months before that motion was argued and 6 months prior to the judgment. And even if they had not been on notice then, they were certainly on notice later and had every right under CPLR 5015 to come in as an interested party who, as they now repeatedly claim, was affected by and had an
They
interest.
never made a motion to intervene in that underlying litigation between you and Fletcher.
Not a thing, not a
Did they,
thing.
did they ever plead the unconscionability of the lease?
You're quite right, they did not, and that was part of Justice Lubell's holding down below. Notwithstanding the fact that they did plead 19 affirmative defenses, there was no defense pleaded with respect to unconscionability or unreasonableness or anything of that sort.
Okay, they claim that Crodell is not distinguishable, that Crodell on all fours applies to this case. Do you want to take a position on that?
I'd certainly like to take a position on that, Your Honor. And first of all, I would note that Crodell, this court's decision in Crodell, which it characterized as being new law, was a year after the final judgment at issue here and should not, under well-established law, be applied retroactively. But even if this court were to look at Crodell's applicability here, I think one must conclude that it's distinguishable both on factual and on policy grounds. Factually, it's distinguishable because in Crodell, the board in that building sought an award of fees when they had not prevailed, and when it was that board that was accused of being in default, as Your Honor suggested in your prior questioning. Secondly—
What about in this case? Your adversary says, Mr. Fletcher brought this lawsuit because of alleged discrimination, and in effect, you're recovering fees for that conduct.
Certainly a portion of his causes of action, I believe he had 13 causes of action in total, a portion of his causes of action were for statutory discrimination, but all of them, including the other 11 causes, 10 causes of action, arose out of the board-shareholder relationship here. The basis of his claim was that the board had not afforded him the benefit of certain policies, which he said should be applied to him as an existing shareholder.
And ultimately, what happened with that lawsuit?
Ultimately, that lawsuit was dismissed on summary judgment
So in other words, the co-op board prevailed, correct?
entirely prevailed.
On the discrimination claim?
Yes, on the discrimination claims and on the breach of fiduciary duty and defamation. And
So would that be another distinction from Cordell then?
certainly, we did not apply for fees here until after we had fully prevailed as a follow-along claim after the Fletcher claims had all been dismissed.
So there's no possibility in this case, for example, that you are seeking fees when you lost, on the
Correct.
claim that you lost for, right?
Correct.
And you're not taking a position, are you taking the position that
No,
paragraph of the lease allows you to collect fees even when you are found to be at fault? 15.
that, it has never been our position that the Dakota is entitled to collect fees when it has not prevailed. It believes that the reasonableness requirement in there incorporates the well-established law that the court should review any fee application and would not approve a fee application where the party had not prevailed. That would lead to exactly the sort of, absurd or inequitable result that was the court's concern under Crodell. The opposite would occur here. The absurd and inequitable result here is if, to respond to your question, Justice Singh, the practical result of vacating that judgment is that the fee amount gets taken out of the Dakota's pocket, the prevailing party, it gets handed to the losing party because Chase has taken an assignment of the losing party attorney's fee claim, the Caswoods claim for fees, which they incurred representing Fletcher in losing that same case. So if one wants to, if a motivating factor under Crodell is to avoid these inequitable and absurd sorts of results, that very same policy and motivation should uphold Justice Bluth's judgment here. And I would suggest that Justice Bluth's judgment and award of attorney's fees under the lease provision was exactly correct because, as Justice Singh, you mentioned, it's plain English. It is unambiguous. In my adversary's brief, they concede that it's unambiguous. At point 5 of their brief, they say, no, at point 2B of
But
their
their
brief.
their point, to be fair, is to say it shows context, and it's context you don't disagree with, right?
We don't disagree with, we don't dispute that memo existed, but it was not the memo that the shareholders voted on and approved. It was the language of the lease amendment. And there is no evidence in the record to show that anybody,
Because paragraph 15 is clear and unambiguous, there's no need for us to go into that memo.
That's correct,
and
Your Honor.
examine it. That's
That is-
for all evidence.
That is correct, Your Honor.
Okay,
Unless there are other questions, I thank the courts for its time.
good. Thank you, counsel.
So how do you respond to your adversary's position, in fact, that they are the prevailing party here, and therefore the unconscionability aspects of Cordell really don't apply here?
And we disagree. We disagree because the way...
Hold on, let's just break that down. They didn't prevail on summary judgment?
On the Fletcher case, they did prevail.
So they're the prevailing party.
They're the prevailing party.
Isn't the prevailing party then entitled to its attorney's fees, reasonable attorney's fees?
The reasonable in amount. I mean, the fact that they did prevail, just like in Crodell, the cooperative corporation prevailed, Your Honor. The cooperative corporation actually did prevail in Crodell. And this court still, in 2018, said, we will not allow these fee provisions to be enforced. And here, where you have an interpretation that's contrary to their own admission, by the way, contrary to their admission, where they went ahead in another court where Chase was not a party, and Chase was not given notice. There were some emails.
You chose not to be a party. You didn't move to intervene. You didn't plead unconscionability of the lease provisions that you're now complaining about, collaterally attacking now.
Judge, it works the other way. For him to have bound, for the Dakota to have bound Chase, they needed to name Chase. There was
No,
no
they gave you
obligation.
notice. All they had, their interest was Fletcher, right? They gave you notice. They shared all the papers with you. It's not like you can say you didn't know about the underlying litigation and you don't need to protect your lien.
Your Honor, I respectfully disagree that notice in an email that we're seeking our attorney's fees, when they sought attorney's fees under the racial discrimination statutes, does not require Chase as the assignee and does not bind Chase as the
But
assignee.
that was only one of the 13 or 14 other causes of action. I wrote a little bit about the Dakota, the causes of action in that case, including the racial discrimination ones.
Your Honor, I see that my time is
Yeah,
up. Can
no,
I just
go ahead,
answer your
don't worry,
question?
that's-
No, I respectfully disagree that that's proper notice. And it doesn't place Chase and it doesn't bind Chase, that Chase is then bound by whatever is
I
decided
just don't,
in that
I
case.
just don't see how you can know about the underlying litigation between Mr. Fletcher and the Dakota. You know it's being litigated in Supreme Court. You don't move to intervene. You don't do anything. Instead, you wait until there's a judgment entered, and now you challenge that judgment only as it applies to you, as if somehow we can keep that judgment alive while not applying it to you. Like I just never heard of that concept before.
It doesn't bind, I respectfully disagree that it doesn't bind Chase. And Chase, given the fact of, especially under
It binds
Grammerton, and I
Mr.
would-
Fletcher, and you're Mr. Fletcher's assignee.
But Chase has a right to say when you're enforcing that amount against Chase, once the Dakota steps forward, the Dakota didn't say, for example, in those emails, hey, by the way, Chase, we're looking to prime your lien, or we're saying that this is a default under the lease, or we're saying that we want to recover these amounts before you're allowed to recover from your collateral. Judge, they didn't say any of that.
Did you
If
get
they
their
did, that's a
motion
different
papers?
argument. But they
Counsel?
didn't say any of that.
Did you-
Counsel, did you get their motion papers?
I'm sorry, Your Honor?
Did you get motion papers? Your adversary states that 4 or 6 months earlier, the full set of papers were delivered to your client.
They sent motion papers, and surely there were e-dockets back then, Judge, but that never said, nowhere in those papers, nowhere does it say that the Dakota was looking to assert a senior position to recover those monies against Chase.
Yeah, but you knew that because you know what the UCC says. They don't have to say that to you. You're a bank. Of course you know that.
The UCC
Everyone knows what the UCC says. They're not trying to seek to assert a lien, a priority against you out of the blue. The UCC says that their lien comes first because they are the co-op. That's not something they have to tell you as a bank. I certainly hope that Chase understands what the priority interests are under the UCC.
And
I
under-
don't know how why you think that they had to say to you at that time, and by the way, when it comes to distributing the sale money, we come first. The UCC gives them the right.
The UCC gives them the specific right under UCC 9102, Section 27D, to secure only obligations incident to ownership of that cooperative interest. And under cases like the Darnett case that's cited in our papers, it doesn't allow cooperative corporations to take these types of fees and other expenses that are not incidental to the ownership of that cooperative interest. And they
Well, I
never
look at
said that in their
paragraph
papers.
15, but paragraph 15 does say that they're entitled to their fees under the circumstances. Wouldn't that be an incident to the relationship between the co-op and its shareholders?
No, Judge, because one, we disagree. We offered a competing interpretation that Justice Lubell just discounted and never discussed. And again, the explanatory comment, yes, Your Honor.
That seems to be a different position now than you took in your brief. I thought we were in agreement that section 15 is clear and unambiguous.
Chase takes the position that paragraph 15 is clear and unambiguous, that the modifier, that the tenant has to be in default, applies to both either shareholder-started, Dakota-started actions or tenant-started actions.
Okay.
So and what we say
So let me
is-
just say, if we agree with Judge Lubell's interpretation, then you're not disputing that under that interpretation, you don't get first priority, the co-op does, correct?
Incorrect, Your Honor, because then you have a clause that's reasonably susceptible to two interpretations.
Okay, let me ask you again. If we agree with Judge Lubell that there isn't two reasonable interpretations, that the language is clear, and that this is incident pursuant to that paragraph, you're not disputing in that instance that you come second.
That's right, if you don't apply Crodell and 1885's ruling as well.
Right.
And you're going to allow a landlord to then pick and choose.
We got that argument, counsel.
Your Honor,
Thank you both.
Thank you for your time.
You got it. Okay, so, thank you. And now we're back to the beginning, people versus, I know I'm mispronouncing this name, Dufresne? Oh, I'm sorry, yeah, that was submitted. So the next one is Nakamura versus motor vehicle accident, but give counsel a few seconds to. Okay. Yeah, thank you for that. Okay, let's hear from petitioner.
Good afternoon, Your Honors. May it please the court, my name is Anthony Mangona from the law firm of Georgopoulos and Malice, attorneys for the appellant. There are 4 issues which have been presented to this honorable court for review. The nexus of the first 3 issues revolve around the appellant's claims and the respondent's denial of basic economic loss benefits, also known as
Counsel,
fault.
is this a hit? I'm sorry.
Go ahead.
Is this a hit and run?
This is not a hit-and-run accident.
So why does insurance law 5218 apply?
Well, law 5218 doesn't apply because other areas of the insurance law do apply. Because the appellant was struck by an uninsured motorist. So there's other ways to recover under the Motor Vehicle Accident Indemnification Corporation Act.
Did you make any kind of no-fault claims in this case?
No fault claim in this case? Yeah, we made
Did you make any claims? Any claims for medical reimbursement?
We received a denial of no fault benefits a day after from MVAC. That's not in the record. That wasn't, we weren't able to present to the lower court that there was a denial one day after that our appellant was not entitled to MVAC benefits because she wasn't a resident of the state of New York.
Yeah, but that issue is really not before us, right? I mean, that's not in the record?
What was the first part of your question?
That issue is not before us on this record.
Well, yes and no. I would argue that that is exactly what's before this court, is that our issues were not fully adjudicated in the lower court. I didn't have the opportunity to go through all of my causes of action. The only cause of action which was analyzed was whether or not 5218 applied to the non-economic loss portion of my claims. I have 3 claims for basic economic loss, which are not addressed in the court's order, and which we didn't have an evidentiary hearing to be able to show that we did all of the necessary steps to be entitled to those no-fault benefits.
So wait, counsel, I'm confused. Did you or did you not make a claim for basic economic loss?
Yes, Your Honor.
And you're stating that despite this, that the motion court disregarded this?
The motion, it wasn't brought up or considered by the motion court. The only thing that was considered was for the non-economic losses.
So did you submit a request for payment within the required 45 days?
Yes, Your Honor. There's a notice of intention to claim in the record, page 34.
So I'm sorry, I'm confused like my colleague. So the denial you got was after the judge's decision, is that correct?
No.
It was before? So
the
why
no-fault-
did you raise that with the judge, that there was a timely application which was denied?
No, Your Honor, because our motion was taken on submission. It was not brought up as an
Or did you
issue.
move to renew? Did you move to re-argue?
No, Your Honor, we moved to appeal the decision because it wasn't considered as part of the order. There was no
How
analysis.
could it be considered if they didn't know? That's where my confusion lies. How could it not have been considered, excuse me, how could it have been considered if it was not known?
Because there's 3 causes of action for basic economic loss in the verified complaint. So the petition, the affirmation and support, and the verified complaint all go through the analysis of why our plaintiff here, a visitor from Tokyo, Japan, is a qualified person under the MVAC statute. And there was a denial of benefits after submitting her hospital bills to MVAC. There was a denial of benefits that she is not entitled to this relief because she's not a resident of the state of New York. But that's
Right,
not
and
what
you're
the
saying
statute says.
5202B2 includes, as a qualified person, a resident of another country.
Correct, Your Honor. And if you travel to Tokyo, Japan, you're afforded the same, you get 30 million yen, which is $227,000 of coverage.
Yeah, what section of the, you said that there are other sections other than 5218 that allows you to recover from the MVAIC?
For the
I thought the MVIAC only pays when there's an unidentified motor vehicle. And in this case, you know the identity of the person, you know the car, you know the license plate. So tell me what other provisions are there that...
Right, Your Honor. 5206 for enforcing a judgment against an uninsured driver. When an uninsured driver is unable to pay, Insurance Law Section 52 allows MVAC to step into the shoes of that petitioner. We definitely have plenty of cases where that's the case. Here, that argument is, I guess, supplemental and to my other arguments that the case should be remanded.
Okay. Thank you, Counsel.
Thank you, Your Honor.
May it please the court, my name is William Badura, and I represent the respondent motor
Counsel, can you
vehicle.
clear up this issue, please? Because it's created
Sure.
confusion in my mind.
Okay.
Was there a timely application for basic economic loss benefits made by the petitioner in this case? And was that denied on the grounds stated by your counsel that she's not a resident of New York?
Although it's not part of the record, I believe so. There was a denial initially.
But you agree that a resident of another country is a qualified person, so...
Correct, I think that's excuse me.
No, go ahead.
I believe it's a red herring in all this, that's not an issue. That's not what our opposition is. Our opposition is pretty simple. Just you look at the notice of petition on page 17 of the record. It's for leave to sue MVIC pursuant to section 5218 of the insurance law. And 5218 is hit and run vehicles.
Also, you're saying they essentially cited the wrong section. Is that really the argument, that they should have been moving under another section of the insurance law?
Correct, and they have to, there's a known owner and operator. They actually brought suit against that known owner and operator, and they have to extinguish all their remedies with respect to that action, and then have MVIC come in.
So you're...
I'm sorry.
go
So
ahead.
their remedies are direct action against the known
Correct,
car owner and driver, et cetera.
which they already brought.
They know.
Yes, that's part of the
They
record
brought
too.
it. And you said they brought it, so
Again,
not obligated to pay, I guess.
no, we're not obligated to pay or to appear yet until they exhaust all the remedies.
So you're
That
saying
action.
essentially, I'm sorry, you're saying it's premature. Once the issues with respect to the underlying personal injury action are resolved, they have the right to seek those benefits before you, correct?
Correct.
And you're also saying that the application would not be untimely, obviously.
But we
I thought
still
you were
have
saying that
rights.
the application could not now be brought because we're beyond the 45-day period.
Correct, there's statute of limitations issues.
Right.
I can't say,
But your argument was that they moved on to 5218. They should not have moved on to 5218 because it was a known driver. Then they could go against that known driver, and then depending upon the outcome, you would or would not take over
correct, with our remedies.
with
of
your
law, such
remedies.
as-
But regardless, now they cannot move for economic loss because they're beyond the 45-day period.
That's our position too.
But how is that your position? They've already, according to your adversary, they already made the application. The application for the hospital bills was denied. So there was a timely application, right?
When they filed a notice of intention to make claim, that includes all benefits, including non-economic loss. So they did file a timely notice of claim.
So,
But they're not, excuse me,
go ahead, finish.
but they're not entitled to no-fault benefits against MVIC until they, again, extinguish all the remedies against
I'm
the
not,
owner of the
I'm not understanding. So I don't know of any lawsuit. If you claim that they should really be going directly against a known motorist,
Correct.
and then at the end of that, if they don't recover, then they can sue you, but you're saying they have to do it within 45 days. I don't know of a single lawsuit in New York that takes 45 days.
Well, that's a submission of medical bills within 45 days.
But they did that.
They did that already.
Not medical bills, they did their application. It's two different things.
So you're saying they still would be time barred because they didn't submit the medical bills within 45 days?
Yes,
Wow.
but again, one of the issues in the underlying suit is
I'm not
whether-
trying to feed you, questions so you can say yes. I'm actually asking questions because I'm unclear as to what the answer is.
The answer is part of the underlying lawsuit, there's an issue as whether or not that owner and operator was insured. And that has to be resolved.
Well, let's assume it's
So
adjudicated.
right now, there's
I'm
a-
sorry, let's assume it's adjudicated and it's found that the operator of the adverse vehicle was uninsured and there's no money. So can they at that time seek basic economic loss benefits?
Based on the early application, which was timely.
Exactly, based on that earlier application.
I don't think there's any bar to them seeking it, but I can't speak to what affirmative defenses they may have.
Fair
to
enough.
Oppose it.
Okay.
But you're not saying that that application is time barred? The initial application, which was denied?
No, because again, they filed a timely notice of claim, and that encompasses that claim.
Yeah. They have a tough road to hoe because, okay,
Well,
thank you.
Here, in a police report, said there was uninsured motor, the vehicle's uninsured. So they could have pursued this right away instead of, this is a 2017 accident.
Yeah,
Now we're 5 years down the road. So
okay.
if there's no
Thank you,
further
Counsel.
questions, I'll rest. Thank you very much.
Go ahead, Counsel.
Good afternoon again, Your Honors. I just want to point out a couple of things. The notice of petition, although it may be poorly worded, there's other prayers for relief outside of 5218 in the notice of petition, specifically those it points to that are in the proposed complaint and the petition, which is annexed to the motion. And at all times, the driver of the vehicle that struck our appellant was known, and that's stated in the petition. So that it's clear that 5218 wouldn't be applicable. It's just cited wrong on the notice of.
I'm sorry, counsel, could you go back to your adversary's position? What's your position with respect to what your adversary says is that you have to essentially extinguish your remedies against the adverse vehicle, the driver, the owner, and then, hold on, and then you can make an application for basic economic loss to MVAIC?
Well, I think there's a confusion over non-economic losses and basic economic losses. When we receive the no-fault denial trial says that if you disagree with this decision, you may file a lawsuit. As you probably know, the AAA, the American Arbitration Association, controls no-fault claims when it deals with insurers. But this is unique in that it's the government entity that would fall outside of AAA. So the only remedy when there's a no-fault denial is not to go to arbitration, but instead to bring a lawsuit, which we've done. So as soon as they issue a denial of basic economic loss benefits, that immediately triggers our ability to bring a lawsuit. And I believe that's not what was considered by the lower court. And that's what I've said over and over again to the Motor Vehicle Accident Indemnification Corporation, that there is a statute in place. I supplied them, I printed the statute from the law of 1955, number 97, that applies in Japan, and sent that to MVAC, but they willfully and deliberately refused to pay any no-fault medical benefits that were presented to them. So that's the reason for the first three causes of action in our lawsuit.
Okay, thank you, counsel. Thank you both.
Thank you, Your Honors.
Lee versus Lafer. No, man.
I have no idea. That's yours.
Good afternoon, may it please the court. My name is Lisa Shrewsbury. I represent the defendants' appellants Max D. Leifer, Esquire, and Max D. Leifer, PC, his law office. This is an appeal from an order denying our motion to dismiss issued by Judge Kelly. The complaint contained one single cause of action for legal malpractice. The underlying action was called Eng versus A Squared, Inc., and the undisputed facts are that Nancy Eng was a 25% owner of two corporations with the plaintiff in this action, Andrew Lee. They entered two shareholders' agreements into
their claim, because you don't have a lot of time, so, they claim that basically they were not advised with respect to their exposure to punitive damages, and that your failure to interpose an answer or a responsive pleading and instead engage in settlement discussion is the nature of the malpractice, right?
That's correct.
It's what cost them the $500 million in punitive damages. So can you address yourself to that? Because you only got 4 minutes.
Yeah, okay, so there was, they didn't file an answer. There was no defense to the facts of the matter. Those facts.
So what is that? So what's the legal implication of that? Are the facts have been established? In other words, breach of fiduciary duty has been established at that point, correct?
That's correct.
And so when you go to the inquest, what's the nature of the hearing? It's really only damages.
Well, right, but it's a 22-page decision, so it was very well thought out. Everyone testified. Judge Modica clearly said that he wasn't sure if anyone was entitled to punitive damages. He looked at everything. He assessed the facts. The failure to file an answer did not put Mr.
But liability had already been established. There was no discovery that took place, right?
The facts had been established, and the facts are undisputed today. There was two shareholders agreements. She was a 25% owner. He collapsed those two corporations into A Squared, a separate corporation, which she didn't have any ownership interest in, and then he sold that.
Yeah, but his position, as I understand it from the record, is that everything was done based on her acquiescing or consenting to that. Now, all that certainly couldn't have come out. She wasn't deposed on those aspects of it, for example.
They testified.
She testified.
Every single, so that's on page.
Counsel, there's a difference between going through discovery and then having a full trial testimony as opposed to being at an inquest where testimony is given, no?
There was no deposition.
There weren't, but everyone
But
testified.
so that's the discovery, right? There are not only documents, but also this testimony. If you have the opportunity for a deposition, then when you actually go to the final stage, you can use that perhaps in cross-examination. That would be important in something like this where credibility seems to have been everything before the judge.
I would agree with you, except in this instance, in the complaint, in this legal malpractice action, in paragraph 14, they state in no uncertain terms that there were two shareholders' agreements. Nancy Eng was a 25% shareholder. Their defense is that, well, she was a nominal owner. Really, her son was the owner, but she was the owner. These documents, people don't dispute the fact that she was the owner. The defense that they raise at this point, and there's no question about.
There's no defense raised. It's an inquest. All you're doing is you're presumably attempting to minimize your exposure to damages, right? That's all that's occurring there.
In the 22 pages, the judge is very, very careful about laying out the facts that are mainly undisputed. And the disputed part really has no bearing on anything.
The disputed part seems to be all about credibility, all about the lack of credibility on the part of Andy Lee. And so perhaps discovery would have made a difference there, as I said already.
Even if that were true, then that would put this into a category of conclusory or speculative damages that no one will never know. What we do know is that we have.
Well, we would have known if discovery had taken place and liability would have been challenged, including exposure to punitive damages, right?
But in a legal malpractice action, it's but for causation and actual and ascertainable damages. They can't be speculative.
So the damages assessed against the defendant, that's not a basis had you filed an answer, you wouldn't have gone to inquest. Those damages would not have been incurred, no?
I disagree. They wouldn't have been able to do anything about the facts. I don't think
We don't know what the facts are until there's been full and fair discovery.
But there was a hearing and a well-reasoned.
It was an inquest hearing to determine damages, not to determine liability.
Well, I think the judge actually is very careful about looking
It
hard.
doesn't matter how careful the judge was constrained by a finding of liability. So the question is, what is the exposure to damages? That's the nature of an inquest, isn't it?
Yes, except in his decision, he says that he has to look very carefully at what actually happened.
He can look all he wants, but
He wasn't.
in the absence. Okay.
I didn't mean to speak over you.
No, that's okay.
He says he's not necessarily going to assess punitive damages. He wants to make sure he assesses a clear and convincing evidence standard. It's really clear that he bent over backwards to look at all the facts.
Okay.
Thank you.
Thank you, counsel.
Good afternoon. May it please the court. My name is Michael Maloney from the Felicello Law PC firm on behalf of plaintiff respondent Andy Lee. I'd like to start by
Counsel,
talking
could you
about
pick up the thread? I'm sorry to interrupt you. Could you pick up the thread that was just left by your opponent, which is that even though it was an inquest, there had to be additional fact-finding because of the heightened standard of proof. There has to be by clear and convincing evidence. And so therefore, the inquest judge was finding facts that were relevant that would touch on whether or not there was malpractice.
Well, Your Honor, the special referee who presided over the inquest expressly declined to consider evidence and argument of my client's defense to those punitive damages claim. In page 99 of the record, there's an excerpt of the transcript of that inquest where the special referee says, in his essence, I'm assuming the truth of the facts and the underlying complaint as to punitive damages against my client, Andy Lee. Those facts alleged that my client engaged in willful and wanton misconduct, essentially quasi-criminal theft, of Ng's interest in this partnership. The special referee expressly said, I'm assuming that to be true. He did not consider the defense that Andy Lee had. As Your Honors have pointed out during argument by opposing counsel, he was constrained by the default. The special referee had to assume the truth of all the facts in that complaint because there was a default. And under New York law, when there's a default, the allegations in the complaint are deemed to be true. That's what happened here. Even the special referee's decision reflects the fact that he declined to consider the evidence offered by my client during that inquest. And I would especially refer to pages 66 to 68 of the record, where the special referee discusses punitive damages in his decision. He discusses only the evidence presented by the plaintiff in that underlying case. And that is exactly the malpractice that occurred here. My client had a viable defense. He continued to pay the profits due, Ms. Ng and her son, Choi, throughout the process, despite the sloppy documents resulting from the organization. Paying profits due is the exact opposite of willful and wanton misconduct that's necessary to support a punitive damages award. My plaintiff suffered massive damages when this punitive damages award was entered against him. And that occurred because of the malpractice of defendant here, Mr. Leifer.
So is that the but-for, counsel?
That is but-for causation here. For purposes of this motion to dismiss, my client has alleged in the motion to dismiss his defense. There's nothing to contradict that defense here on this motion to dismiss. Those allegations of that defense must be assumed to be true. We have also alleged that the special referee refused to consider that defense during the inquest, resulting in entry of the judgment.
Okay. Thank you, counsel.
Thank you, Your Honors.
Just quickly, with respect to the potential defense that 25% of the profits were paid for a period of time, the judge did take that into consideration. But the basis for the punitive damage claim was the merger of the assets of the companies that Ms. Ng owned into another company that she didn't own, and then the sale of that company at a discount to his...
Did he get an opportunity to confront that issue?
Yes.
Explain why?
Yes.
In the context of liability?
I think if you read the judge's decision, which starts on page 54 of the record.
We did look.
Well,
we did read it.
I think it's clear that all of those...
I don't think it's that clear. I think that, as counsel pointed out, that those 22 pages basically do not, he doesn't go into any discovery that may have taken place, any explanation that was given for merging that company, the two companies into one. He didn't get an opportunity to explain the bona fide benefit of what he did, of his action. Instead, the allegations that were made that basically he defrauded the underlying clients in this case was true.
Well, it was true. And I think that's clear in the decision. I understand what you're saying, and I respect what you're saying, but there really was no defense.
I'm reading the decision now. I'm reading that portion of it, and what he states is that he states what the complaint, the allegations in the complaint, in terms of punitive damages, and then what he goes into actually is whether or not there's a legal basis for punitive damages based upon those allegations. He doesn't specifically state whether the allegations are true or not, because he has to accept them as true because of the default. But what he talks about, and he goes on for a number of pages, is whether whether punitive damages can be awarded when you're talking about breach of contract actions involving only property rights, et cetera.
True, but on page 2 of the decision, he talks about the fact that he considered the testimony of all the people involved and the legal brief submitted by the attorneys for everyone.
Right. He also says that this matter is sent before me for an inquest as to damages only.
Okay, thank you, counsel. Thank you both. Pierce versus City of New York.
Thank you, Your Honors, and may it please the Court. My name is Christopher R. Block from the Office of Albert W. Cornacchio, PC, for Plaintiff Appellant Destinisha Pierce. The trial court's grant of summary judgment to the defendant city in this action is inconsistent with this court's holding in Handelsman v. Llewellyn from June of 2022. An examination of the facts on this record in the context of the four-factor analysis presented in Handelsman demonstrates that there are significant questions of fact and credibility on this record that needs to be presented to a trier of fact.
Counsel, wasn't there an important distinguishing fact about Handelsman is that there was plenty of evidence that the police were speeding and going at excess speed, whereas here we have the GPS data which appears to show that they were not doing that.
Thank you, Your Honor. The GPS data that's presented here, it exists, however, it is vastly incomplete, and it was clearly cherry-picked, selected by the police officers who took the raw data and then presented a few selective points and put them on a map. Now, in Handelsman, I understand there was an argument regarding the spoliation. However, it was not granted because it was procedurally out of order. It had not been presented to the lower court at the proper time. In our action, the litigation that kicks off everything here was a motion to strike the answer of the defendant city for this exact destruction of evidence, which they essentially admitted to. So,
Well, with respect to the raw data, right?
that's correct. The raw data was destroyed. They presented some selective
Did you
facts.
ask for a litigation hold of any kind?
We did. We had asked for litigation hold. We'd actually litigated this for a couple of years.
After the litigation hold, was there still, was data destroyed, or was it before the litigation hold?
It was after the request for litigation hold. Additionally, even at the moment of impact, the police officers, they went right to the scene. They saw the condition of my client. There's an expectation, there should have been an expectation of litigation at that moment that required them to place their own litigation hold automatically.
But based on what? I mean, you have a car which is speeding. You have a driver, Mr. Wilson, I think, who acknowledges that the car shouldn't be on the road because it's not roadworthy. I mean, what are the bases to believe that there's going to be litigation with the police department?
Based on the condition of my client at the time, she was severely injured. I should also add, Xavier Wilson's testimony regarding the condition, the defective condition of the car, it lacks credibility to some degree. His testimony overall lacks credibility, but specifically as regards this car, this is an 18-year-old driver at the time. This is not his vehicle. Just due to his age and his inexperience, he's not a credible witness to describe.
But he knows. I mean, he says he was driving too fast and in an unsafe car. He knows in fact, the car had been recently repaired and not appropriately, right?
Well, the car had been repaired. It had an axle repair. An important part of this, though, is that the testimony of, for example, P.O. San Marco, he sees the final event. He sees what happens with this vehicle. This vehicle hits a dip in the road, and it goes airborne. There is no proper condition of shocks or brakes or power steering that's going to allow an airborne vehicle to be steered or to properly stop.
But that's because he was going too fast.
Yeah, if you're going 80 miles an hour, of course. I'm not understanding what you're saying, counsel. He said he was going too fast. He said he was speeding.
Yes.
So yeah, if you hit a pothole in New York and you're going 80 miles or you're speeding, you may take off.
We brought this action against Xavier Wilson also. He shares in the cause. My contention at this point is that the lower court held that Xavier Wilson was the sole proximate cause, and that's not the case.
But was there some evidence or testimony by anyone or anything that the police were speeding?
Well,
I understand that there's limited raw data here, but was there something that would have precipitated their thinking that there should have been a litigation?
Yes, Your Honor. My client, first of all, testifies that the police were going fast, and I know that's a general term. However, there's important testimony at R174 through R180 where P.O. San Marco is shown video evidence with timestamps. We also know that the police vehicle, the entire event takes over the course of about 3 avenues, and the police get a late jump. They do a U-turn and follow the Xavier Wilson vehicle. They stay with him throughout the course of the chase, and there's significant testimony.
They lost them for a minute, purportedly because they were not going as fast as Mr. Wilson was.
That's correct. At the first corner, they lose him for a second, but then they make the right, and they're with him the whole time after that. There's significant testimony that Xavier Wilson's traveling at highway speed.
When you say they're with him the whole time after that, I think they said I forget how many car lengths behind. I think they said 10 to 12 car lengths behind. So they're driving at a slower speed than he is.
And that's why I make reference to the testimony at R174 through 180, where there's time-stamped evidence demonstrating that at the end of the pursuit, there's video evidence that captures the end of the pursuit on security cameras, and it shows that the police vehicle is between 2 and 8 seconds behind the Xavier Wilson vehicles right before it crashes. When this is taken in the context of the police testimony that they also were cut off by what P.O. San Marco describes as a three-wheel motorcycle vehicle, immediately prior to that, it shows that they did keep up with him as Xavier Wilson traveled 60 to 70 miles per hour. They also give a very intense description. P.O. San Marco in particular gives a very detailed description of the events that end this pursuit. He sees with great detail a dip in the road and the vehicle launch into the air. So they do truly stay close enough.
I thought it was a bump in the road.
It's alternately described as a bump in the road. P.O. San Marco describes it as a dip in the road. It's clearly a sort of a down and then a hill that launches the vehicle into the air.
Thank you, Counsel.
Thank you, Your Honor.
Please, the court. Janet Zalian for the city. The court's questioning demonstrates that you understand that the police car was behind, but never close, and getting
How far
further.
behind was it?
I'm sorry, Your Honor.
How far behind was the police car?
The police car was the most that Pierce sees is two what she calls house lengths behind. Now let's say, or Bronx house lengths. So let's say the houses are only 10 feet wide. That's 20 feet. That's not like.
So 20 feet behind, but keeping up, right? So is counsel correct that essentially the cops were speeding too?
She sees it at one point, Your Honors. She sees it about a block or two behind, but what Wilson says is that by the time of the accident, because remember, this is only occurring a block or two into Mount Vernon. There's one block on Seton. There's one block on East 241st Street. There's a couple blocks into Mount Vernon, and that at that point, first of all, everybody agrees that they're speeding here. Everybody agrees that the Wilson's car took off. And
Wilson himself says it.
And he says it, and he says, I'm sorry, it's my fault, go sue me, you can sue me. And he admits, of course, that his car, as the court's questioning indicates, is in terrible condition. He thinks that the reason it went airborne and then crashed down and crashed into the parked car is that the axle that was recently repaired broke again. What happened here is that the police were behind, but they're far behind. And contrary to what the appellant repeatedly says in the reply brief, there is no evidence that Pierce is seeing the police car right before before Wilson's car speeds out of control. She's saying it's a block or two away, and that's actually consistent with the police officer's testimony that they had terminated the pursuit a block or two before the accident. One word about spoliation, Your Honor. The testimony from Lieutenant Sena is that this software or GPS data records details at intervals. There is nothing but utter speculation to say that all of the 10 or 11 second intervals that Lieutenant Koshmerl, who's retired, there's no reason to believe that he didn't record all of those intervals. And that's why you can see from all of those intervals that there is no speeding going on here by the police. That is totally different than Handelsman. And by the way, with regard to Handelsman, remember, this is a different part of 241st Street where it's a big street. If you look at Google Maps, you can see that in the area of the accident in this case, it's split off from where 241st curves away from Baychester Avenue, and it turns into a little street. At the time that the Handelsman accident, the place where the Handelsman accident occurs, at 80 to 100 miles an hour, viewed by a police officer who has seen the whole accident, the whole chase unfold. And that's a totally different type of street at that point. Your Honors, if the court has no further questions, we'll ask that the court affirm, and we'll rest on our brief, and we thank you very much for your attention.
Thank you, counsel.
Thank you, Your Honors. I second my adversary's request that you do look at the Google Maps record, what exists on Google Maps for this location. And I'm shocked that you would refer to this as a little street. This is a residential area. There are people walking these streets. It is 5 to 5:40 p.m., described at various times in the record. This is the least ideal place for a high-speed pursuit in motor vehicles to take place.
I'm sorry, counsel. How do you respond to the argument that, in fact, the pursuit had terminated prior to the time the Nissan went airborne?
Thank you, Your Honor. There's a question of fact as to whether the pursuit had terminated. There's also...
There was evidence in Handelsman, wasn't there, that the pursuit had terminated? I'm sorry, there was also evidence in Handelsman.
Yes, and in Handelsman, this action was sent back to the trial court to be heard by a trier of fact. If the pursuit was terminated, I understand the police say subjectively they terminated the pursuit. That is not something that would have been understood in the Xavier Wilson vehicle. My client is yelling at Xavier Wilson from the back seat the whole time up until impact.
Well, once the accident took place, the police came in 8 seconds after, right?
I'm sorry, what was that?
Once the car went, Mr. Wilson's car, the white Nissan went out of control and hit another vehicle, the police came in 8 seconds later. Right?
The police raced up 8 seconds later. That is correct. But
8 seconds is a long time. They weren't right on top of them.
That is correct. However, P.O. San Marco also testified they had been cut off by a car that had pulled out in front of them in between the chase. Now, from the perspective of the Xavier Wilson vehicle, again, my client is saying,
But it was
stop,
after
police.
that they ceased the chase. The car cut them off, yeah, but the testimony was that they had ceased the chase. They stopped.
Yes, that is their subjective testimony. That is in their opinion. They say they
Why is
stopped
that
the chase.
subjective?
Yeah,
I don't see, why is it subjective to testify we ended the chase?
Thank you, Your Honor, because if you're in the Xavier Wilson vehicle, that chase is not necessarily over if you have flashing lights appearing around you and the person in the back seat is yelling, the police are behind us, stop the car. Additionally, prior case law has sent questions like this back to a trier of fact where this pursuit was called off shortly prior to. It's not an exact moment thing. When there's a short period of time, it goes to a question, it goes to a trier of fact.
Thank you. Thank you both.
Thank you, Your Honor.
People versus Guzman.
Good afternoon. Karen Brill for Ryan Guzman. Ryan Guzman has been addicted to opiates since he was a traumatized teenager struggling to deal with a violent home life. That addiction is behind his entire criminal history, including the instant offenses.
Counsel, you do a very good job in your brief spelling out that history. However, here there's also the gang assault in jail, which it seems like you want us to reduce it to 5 years. Is that a bad message to send about participating in violence while incarcerated?
I don't think so, Your Honor, for a few reasons. One, even the gang assault was inseparable from his addiction. It occurred just 3 weeks after his arrest on the instant sale charge here, and the PSI is a bit muddied on this point, but at that point he was either in withdrawal from, at that point, a decade of serious opiate addiction, or was high at the time of the offense. So I think it's still part of that period of time where he is really suffering from this very prolonged serious opiate addiction that he had not had the benefit of treatment.
Is there anything in the record that suggests that he was going through any type of withdrawal at the time of this gang assault?
Not explicitly, Your Honor, but we know that he had
About implicitly. I mean, I don't see anything that spoke about him going through withdrawal or having any issues or anything like that, which led to this attack on this fellow inmate by he and others.
Right, so I think more of as a common sense inference that it was 3 weeks after he had been on the street selling drugs in order to support his own use. And this had been, again, more than a decade of Percocet addiction, and it is hard to come off of an addiction like that abruptly. But I would also just point out
Is there anything in the record that suggests that if you're coming off Percocet, that you're going to behave in a violent manner towards others?
No, Your Honor, and that's the other point I was going to make, is that even beyond that, this was truly aberrant for his criminal history. And I don't mean to minimize the seriousness of the offense, but obviously the penal law sets 5 years as an appropriate minimum for some gang assaults, and I think that's appropriate here, where he had absolutely no history of prior violent criminal conduct besides this, had never been so much as arrested for a violent crime before this, and where, to be frank, it did occur in a jail where that is a disproportionate site of violence, and it's hard to avoid violence. And again, I'm not
He has
saying
a
that.
prior violent history, doesn't he?
No, Your Honor. He has no prior violent criminal history. This was the sole violent crime.
I mean, going back to 2009, I mean, he has a criminal trespass, a disorderly conduct, and a theft, among others, right?
Yes, Your Honor, none of those are violent crimes under the penal law, but I take your point. But I think just more overarching, I would again, ask the court to look at his overall, the addiction that was occurring during all of that time, and to consider that he had not had the opportunity for treatment since he was 20 years old. He's now 34. He's a fully developed adult.
He only got 6 months over the minimum, right?
He got 1.5 years over the minimum, Your Honor. We're asking for 1.5 years for
I thought the minimum was 6, and he got 6.5.
The minimum is 5 years here.
Oh, okay.
So yes, just as I was saying, this is his first opportunity for treatment since he was 20. He's now 34. He's a fully developed adult. He has an adolescent son of his own for whom he is motivated to stay sober. He has professed his commitment to sobriety. And I just add that he also will be serving 5 years of post-release supervision after he serves his prison time. And that is substantial structure and support, in addition to actually a really substantial family support network, to help him as he readjusts into the community and seeks necessary services for what has been a harrowing history of addiction that has really been the driver of the criminal behavior here. And so we ask this court to reduce the sentence. Thank you.
Thank you, counsel.
Good afternoon, Your Honors. Good afternoon, Your Honors, and may it please the court, Samuel Goldfein on behalf of the people. Defendant here, his conduct and his criminal history demanded a sentence that was above the bare minimum. Defendant, while incarcerated, pending a drug crime, a felony drug crime that was serious, he sold oxycodone to an undercover officer with 4 other inmates, attacked a man unprovoked.
But he was not what was his complicity with the other inmates? I mean, I recognize they're acting in concert, but specifically what did this defendant, is it alleged that this defendant did?
It's alleged that he shoved, kicked, punched, and stabbed this man, causing a variety of injuries, multiple.
Is that correct, counsel? Wasn't it the other 2 co-defendants who did the stabbing, or is it the claim that Mr. Guzman also was part of the stabbing?
Mr. Guzman admitted in his pleading guilty to attempting and intending to cause serious physical injury. He also mentioned that sentence that he was armed with some kind of weapon. He called
said
it
it was a spoon. Didn't he say it was a spoon?
He did, yes, Your Honor. He said it was a spoon, but given the nature of the injuries to the victim suffers lacerations and puncture wounds. He needs to be medevaced to Bellevue Hospital. I don't know what kind of spoon it is. Perhaps it's been modified in some way, but nevertheless, defendant is armed, intending to cause serious physical injury, and does attempt to cause that injury.
The question was, of those various people and the weapons they had, was there a weapon that was used by someone to cause this injury? Do you know? Was it Mr. Guzman, or was it one of the other people who actually struck the blow that caused the injury? Do you know?
We know for certain that Mr. Guzman struck the victim. We know that for certain.
Right. You said kicked, punched, but we're talking about the stabbing.
Yes, Your Honor. So we don't know specifically. There's no direct evidence that he is the stabber, but we know that he's armed with some kind of weapon, and we know that he's acting in concert and that these injuries do occur to this other inmate. And all this is happening while defendant is incarcerated pending felony charges. Setting aside, then, he has a pretty extensive criminal history. It's multi-state. It includes other felonies. This context demands a sentence above the bare minimum. And then the other point that was really not discussed.
Counsel, what were the other felonies? Because I thought that it was only your adversary had said that the criminal trespass.
There was a drug possession as well, I believe, Your Honor. Two prior felonies. This was his 3rd and 4th felony convictions. This was the first violent one, but prior felonies.
Yeah.
And the other part.
So basically, he's a junkie.
Well,
They're all related to drugs, right?
Some of his crimes appear related to drugs, and I think that was certainly accounted for by the sentencing court. I mean, the sentencing court here undercuts the people's offer and gives him a very good deal, 6.5 years. He faces 15 on the gang assault alone and 12 on the drug possession. So, I mean, the court is accounting for those factors. That's why he gets such a low sentence. It's above the minimum, but just barely. And in context, I think that's a reasonable sentence and appropriate here. The other factor is that there was a very good waiver in this case. The court's oral colloquy was textbook. The written waiver form
It was far from textbook, counsel. I wouldn't belabor that point at all. The judge basically referred the defendant to his lawyer and said, talk about it with your lawyer. He didn't say very much at all. The written waiver is okay, but even under Thomas, which allows a lot, this seems like a pretty bad colloquy to me.
Okay, I mean, I take Your Honor's point about the colloquy. I think that he made it very clear that the rights were separate and distinct, that he was getting the right to appeal was being waived as a specific component of this plea deal in exchange for the very favorable offer.
Yeah,
I mean,
to
all
the
of that
extent
is
permitted by law, the judge said. No, and then Mr. Guzman says, by law? What does that mean? You know, he's question mark.
Well,
He's
exactly.
unpacked that for me, Judge, and then the judge said, talk to your lawyer.
And then there was a pause, and there was a conference, and then the defendant confirmed afterwards that he was fully aware of the rights that would survive and the rights that he was waiving. I mean, the judge, there's no mandatory catechism. The judge ensured that he understood what was going on. Defendant said that he understood what was going on, and intelligently, he received a very good plea deal in exchange for waiving his right to appeal.
Okay.
There are no further questions. I ask that you affirm, and I rest on the brief.
Thank you, counsel.
Thank you.
I'll just briefly clarify the assault conduct really quickly. I just want to clarify that at sentencing, what Mr. Guzman did say was, all I did was punch somebody, and the PSI backs it up. It says that defendants Augustin Guzman, which is a different Mr. Guzman, Javier, and Raylan all appeared to stab the victim with sharp objects.
Well, he's punching somebody
Yes,
while
I don't mean to
the
minimize.
victim is getting stabbed by the others,
Yes.
right? That's the whole nature
I don't mean
of
to
gang.
minimize Mr. Guzman's
And he
actual
did say
offense conduct.
he did say he had a spoon. We don't know whether the spoon was modified or the substance of the spoon, what it was made out of, but he does admit that he punched and kicked and also that he had a spoon.
Sure, I just do think it is worth considering as part of understanding why this really was aberrant, that Mr. Guzman, unlike the other co-defendants, does not seem to have come into this with the same premeditated behavior of having like forged a jailhouse weapon. Just to go back a little bit, you know, I just think overall, well, my time is up, but.
You can finish your sentence.
Oh, okay, well, thank you. Yes, I just think overall, you know, all of this happened again before he had an opportunity for treatment in more than a decade and a half. So I'd ask that this court recognize that as an inflection point and reduce his sentence. Thank you.
Thank you. Franklin versus Shallow River.
Thank you.
Excuse me. I know coughing is a scary thing to say.
Exactly. Thank you, Your Honors. Good afternoon. May it please the Court. My name is Neil Palmieri. I'm with the law firm of Bongiorno, Montiglio, Mitchell, and Palmieri. I represent the defendants, appellants, Alexei Chalov, Reber Corporation, Reber Transportation, and Reber Transport, Inc., collectively referred to as Reber in this appeal. This litigation arises out of a rear-end collision which occurred in the overnight hours back in May of 2012 on the New York State thruway.
Counsel, I've got a big question for you about Mr. Chalov's testimony. It seems to me that he doesn't definitively say anywhere in the record that he had his lights on at the time of the accident. Can you cite me chapter and verse to record pages that say that? Yes, the lights were on when I had because we have Mr. Pete Rose's, I mean, you know I'm asking this question. We have Mr. Pete Rose's testimony, like the lights were not on, and similarly from the two respective plaintiffs.
I can address that, Your Honor. That is true. He never once definitively states I had my lights on. He does, however, definitively testify, as noted in the record, that he did a pre-trip inspection and that the lights were lit.
When was that pre-trip inspection?
That was, I believe, approximately 2 hours before the accident when he
And
just...
doesn't he also, I think it was in another deposition, isn't he equivocal about whether or not he did the inspection?
I don't believe so, Your Honor. I believe that he was definitive on.
I think he was asked finally, after going back and forth, he was asked, what I'm hearing basically is that you don't remember inspection, and he said, no, I don't.
He does at various points, and I believe it's noted in my brief, that he is, his testimony is not the best.
Well, you said, I mean, I think a little while ago, in response to my colleague's question, you said the record is definitive that he checked his lights and that the lights were on. So I don't think that that's a fair statement. I don't see that the record is in fact, that he was definitive that his lights were on. Is there anywhere else in the record that shows that where he states definitively that the lights were on? He said, I think I checked it. I might have checked it.
Right. So he does, the problem is it was a 2-day deposition, and in page 790 of the record, he states about doing the inspection and that he checks to see if the lights were on pre-trip, which I did. So that's 790 to 791. You are correct that there are other parts of the deposition where he is indecisive and he does not remember, but he never once testified that he did not have his lights on.
Is there a disinterested witness to the accident?
So if you're referring, Your Honor, to there's a non-party witness, Pete Rose, but he acknowledged at his deposition that he did not witness the accident. He came upon the accident immediately.
I'm sorry, counsel.
No, I'm
Mr.
sorry.
Rose, hold on, counsel. Didn't Mr. Rose go around to the front of the truck and then see that, in fact, that the truck's lights were not on? Isn't that what he testified to in sum and substance?
That was his testimony, but that's after the impact occurred, after the accident.
Right. He says when he immediately came upon the accident, that the lights were not on. That's what Mr. Rose testified to.
That is his testimony. That is correct. But I would also note he did not witness the accident, and neither did this first responding state trooper, who did not issue...
When you say he didn't witness the accident, he didn't actually see the impact, but he was right there. His head was turned. I mean, he was there at the time of the impact. He just wasn't looking right at it. And he came right in within seconds to the car, and the lights were off. Are you suggesting that the accident and the impact caused the lights in the cab of the tractor trailer to go off?
I cannot make that suggestion, Your Honor. I am not making that suggestion.
So that the lights were off within seconds of the impact. That is testified to by a
non-party witness, but I would counter that just with the fact that the state trooper, the first state trooper to arrive immediately after the accident, did not cite Chalov, Reber, the appellant, for not having their lights on.
Well, that doesn't mean they weren't on. That means he didn't cite them for it.
But again, I would
off.
Refer to the note that Pete Rose did not witness the accident.
But how long after the accident did Mr. Rose approximately get to the front of the car?
I believe it's within minutes pursuant to his testimony.
Right, because he first attempted to help the plaintiffs, and then he went around. So it's
Correct. And the other factor I would note is that there's reflective tape at the rear of the Reber truck. The Reber truck, the appellant truck, is the lead truck, and the Nieves truck, one of the respondents, is the following truck.
Where did this accident occur? Was it on a straight road?
On New York State Thruway.
Where did it occur? Did it occur on a straight pathway, or was there a curve?
Right around a curve.
It was a blind curve on I-87 at 2:30 in the morning.
Correct.
Right? So you're talking about reflective, whether there was reflectors or not. If you're coming around a blind curve, Are you going to see this?
Respectfully,
blind
Your...
curve?
I'm sorry, Your Honor. Respectfully, though, that same argument holds true for the premise that you're under an obligation as a driver to see what there is to be seen in front of you.
You just said it.
Exactly.
Thank you, Counsel.
Thank you.
May it please the court, good afternoon. My name is Suren Israeli and I represent Gregory Franklin. Gregory Franklin is the passenger in a Ryder truck. The court questions already covered all my notes, so unless there's any specific questions that I'll just raise on my brief, just want to simply say that there is no evidence whatsoever that at the time of the accident that the defendant's vehicle lights were on. All the evidence from 2 parties and one independent eyewitness indicates that the lights were off. Therefore, there's a clear violation of a vehicle and traffic law 375, subdivision 2.
Thank you, Counsel.
Thank you.
Your Honors, if it please the court, Mark Cambereri from Sobo and Sobo for the plaintiff respondent, Jonathan Nieves. This is the first time I've been in front of the first department. This courtroom is beautiful. I don't mean to take up your time. So, partner comes to me, says, Mark, I represent Jonathan Nieves in a huge injuries, and we got a motion to dismiss. Can you do that? And I said, yes. Can you also make a cross motion for summary judgment? What? This is a first. So, going too slowly, I can't establish negligence as a matter of law, but unless I could say there was another statute violated. So I looked at all the depositions and the experts' report, and I noted that nowhere did the fellow say his lights were on. And so, with the lights being off, it's a violation of the statute.
Why isn't the reflective tape in itself, based on the expert's testimony, sufficient to raise an issue of fact?
The reflective tape is like the red and white tape that you see on trucks. And they only had, in the photographs, you can only see like 2 pieces on the top. And our expert said, well, you know, that it's a tanker truck, so it's convex, so that the reflective tape goes up, and there wasn't enough of it. And then he cited 2 regulations by the International, I strike that, the Interstate Commerce Commission, the Federal Department of Transportation, that required reflective tape be along the bumper on the bottom, and more of it be around the circle of the back of the truck so that you could see it. The statute, the VTL says, you're supposed to have a lights on if your vehicle's made after 1952 that can be seen 1,000 feet away. So obviously, 70 years later, you would think that the lights would have been improved and brighter, but it couldn't be. This was I-87 at that point in Rockland County, go straight for like 2 miles, and it hits a curve where there's an overpass. Obviously, the overpass has abutments that support the overpass, and so when you go around the curve, they block the line of sight. So he traveled at the normal speed, he couldn't go any faster. As soon as he got around the curve, this vehicle was traveling less than 20 to 25 miles an hour with its lights off. It was a danger that caused the accident.
Is it your point, counsel, that by the time he got upon the vehicle, there was no way for the truck to brake and stop in time? Is that the point you're trying to make?
Yes, that's what happened. He swerved to the left. The damage to the vehicle, he swerved. The turn was to the right, so it blocked his line of sight. As soon as he got through the turn, the vehicle was there. He swerved to the left because they were in the right lane, and the damage to the vehicle is more on this side on the front, proving that he swerved, proving that he was attentive and not asleep, and that was just a sudden emergency situation that he had confronted.
Thank you, Counsel.
Thank you, Your Honors.
Your Honors, the final point that I would like to make is that if this case is going to be decided on the testimony of a non-party witness, in part at least, then that is a question of fact, and summary judgment should not have been granted to anyone. So in the first instance, of course, as the lead vehicle, I believe it is our position that Reber was entitled to summary judgment on liability, but alternatively, no one is entitled to summary judgment based upon the fact that there is a contradiction in the testimony.
Thank you.
Thank you.
Thank you all. People versus Rivera.
Good afternoon, Your Honors. My name is Hillary Dowling, appearing on behalf of Appellant Raymond Rivera. For the two convictions contained in this appeal, Mr. Rivera received an aggregate prison term of 16 years. In light of several mitigating factors, particularly the circumstances surrounding his initial release to receive treatment and his subsequent rearrest, we are asking this court to reduce his aggregate sentence to 10 years in the interest of justice. Mr. Rivera, who is currently 54 years old, struggled with serious mental illness and corresponding drug abuse since early childhood and throughout his adult life. This lifelong struggle is reflected by Mr. Rivera's extensive criminal history.
So in the first case, the burglary case, he would have been, when he took the plea, right, he was supposed to enter a program. Is that correct?
Correct.
Because he was going to be given an opportunity to deal with all of his issues concerning, including his substance abuse. Is that correct?
That's right.
However, he violated the conditions of that plea in sustaining the new arrest. Is that correct?
Correct.
And he was told at the time that if there were no new arrests, that he would get a lesser sentence, but if there was a new arrest, then all bets are off, right?
That's all correct, yes. The lifelong struggle that I was referring to, particularly his serious and persistent mental illness.
And that lifelong struggle would have been addressed to some extent if, in fact, he had completed the ACT program.
Okay, well, I guess that is sort of the crux and the main argument in our brief, is that the way that it happened when he was released to receive that program, the agreement was that he needed intensive inpatient services to address his complex treatment needs. However, when he was released to receive these services, no beds were available, and he was...
How long did he go without medication when he was at the Mika shelter?
He didn't receive any medication while at the shelter, and he started experiencing symptoms of his psychosis, including hallucinations, within 4 days of not receiving that medication.
And the crime involving the blind woman was 3 weeks later?
That sounds right. I'm not exactly sure about the amount of time, but it was very close within he was released to this shelter.
So those 3 weeks he spent at the shelter instead of in an inpatient facility where he was supposed to be medicated, and he was in the shelter without medication.
Correct. And that does go to my point, is that, instead of receiving these services, which all parties agreed, including Mr. Rivera, that they were necessary to address his complex needs and his serious mental illness. He needed his antipsychotic medication to remain stable. And he got sent to the worst place he possibly could. The shelter, it was a disastrously unstable environment, was not equipped to deal with his serious mental illness, and he was unable, despite multiple efforts, to make contact with the program, and he was unable to receive his antipsychotic medication. Soon after, he was rearrested, in all likelihood while in the midst of a psychotic episode. There's no dispute that Mr. Rivera violated the terms of his initial plea agreement by incurring a new arrest, but the terms of that agreement contemplated intensive inpatient care to address his needs. based on the recognition that anything less than that level of care would be utterly inadequate and set him up for failure. And those terms of that agreement were broken for him as well. The circumstances surrounding his initial release to receive treatment and subsequent rearrest in no way justifies or excuses his conduct, for which he accepts complete responsibility. However, those circumstances provide a necessary and critical context and must be considered in considering whether his prison sentence should be reduced to the 10 years requested. Of course, as my adversary will likely point out, Mr. Rivera could have received a longer prison term and faced consecutive time if he was convicted after trial. But this fact does not mean that the sentence he received was fair, particularly in light of his history, age, and the exacerbating
Counsel,
circumstances.
can I ask you about the recent history? There were 3 hospitalizations between January and March 2016, correct?
Correct.
And was that before the court, and was it unpacked what those hospitalizations were for?
I'm sorry, say that one more time.
Was it explained what those hospitalizations were for?
Yes, he essentially had been on correct medication, going to substance abuse treatment, and remained arrest-free for approximately 2 years until that period of 2016. Following the sudden deaths of two of his siblings, it triggered a decompensation where he was hospitalized to stabilize mentally those 3 times. And it was during that time of decompensation, after being arrest-free for 2 years, that he incurred the first arrest in this case.
Yeah, why don't we end it there, Counsel, and you got
Okay.
2 minutes on
Thank you.
rebuttal.
Good afternoon, Your Honors, and may it please the court, Emily Galt for the people. I just want to point out first that it was only 11 days, not 3 weeks, between the plea agreement and defendant committing this crime. There's really no indication in the record of when he stopped receiving medication, if he even did stop receiving medication.
Well, I think he said at some point in time, I think he said that he had not been given his medication.
Right, but we're not sure when that actually was. All we know is that he pled guilty and took this plea agreement on...
He said there were 4 days I didn't take my medication.
Okay. But in any event, there's no indication that he was not aware of what he was doing at the time he committed the crime.
Well, he said he didn't know, he stated that, I don't know what happened, I don't know how I got here, I don't remember how I got here, I didn't take my medication.
Right, but he's not saying he doesn't know right from wrong, and he didn't know that attacking a blind elderly woman in the lobby of an apartment, there's no indication that he didn't know what he was doing when he said that. And in any event, these circumstances were known to Justice Convisor, and she took them into account when defendant pled guilty in exchange for a 16-year sentence. This was a fairly negotiated plea deal, and he actually...
Counsel, I'm sorry, did the people ask for less? They asked for 12 years, did they not?
No, that was for the second-degree burglary that he was pleading guilty to, that he took the plea deal on. We asked for 12, and he received 10 on that. He could have, I think the minimum was 7. This we asked for, I believe we did ask for 15 on, or I'm sorry, 16 on this. But defendant received several benefits from this. He was a second violent felony offender. This was his 4th felony conviction. He was facing up to 25 years on this crime alone, yet received 16 years on this, again, for attacking a blind elderly woman who was coming back from church.
She was elderly, she was 59, right?
I think the record states that she was elderly. I
Well,
apologize.
you said she was elderly, but I just wanted to make sure she was 59.
Yeah, I would answer that if I were you.
I don't recall her exact age.
It was 59.
I apologize. Also, another benefit he received is that this sentence was dating back to and running concurrently with the second-degree burglary conviction that was not related to this offense. So, defendant was sentenced for this crime on October.
Well, it was non-proton, so he got credit for 8 months.
Right.
8 months taken off the 16 years.
Right, and it was running concurrently with that sentence as well. The presumption is these were 2 unrelated offenses. He could have received the 10 years plus the 16 years for a total of 26 years. He didn't. He's serving 1 term of 16 years.
When was the other felony?
I'm sorry?
When was the other violent felony?
The other violent felony, it was robbery in the first degree, and I believe that was 2011. And he had grand larceny convictions. He also was a multi-state offender with offenses in Maryland, and he also had federal convictions.
And the parole violation was for that for the robbery?
I'm not sure, Your Honor.
Was there a parole violation as well?
He has parole violations as well, yes. So given all the circumstances, defendant's sentence should not be disturbed on appeal, and if Your Honors have no further questions at this time, we ask that you affirm.
Yeah.
Thank you.
Thank you.
Thank you. I will initially
Counsel, it
note.
was 11 days, not 3 weeks.
Correct.
And MICA programs, I don't know if, it's over here.
Oh, sorry.
I don't know that MICA programs provide any medication, do you?
I'm not aware of what they're.
So then we have to take the defendant's word as he hadn't had any medication for 4 days, at least that we know.
Well, that's correct. He never received any medication during his time at the shelter. So any questions about when he stopped receiving medication is when he was released from custody. He was receiving medication while incarcerated at Rikers. As soon as he walked out those doors and was sent to that shelter, he could not get medication. The program had not been in touch with him to facilitate that while he was in this temporary placement, and he received none during those 11 days that he was at the shelter. I will also I do take issue with the people's representation that they also made in their brief that Judge Convisor was fully familiar with all of these circumstances and facts that I have addressed, particularly with his release to a shelter instead of an inpatient facility and his decompensation. The only thing that Justice Convisor said during sentences was that she was fully familiar with the facts and circumstances of that case. That is the chain snatching case. She was not the judge who took the plea or sentence on the initial case that involved this release to this, that was supposed to be to this program. Nothing in the record indicates that she was aware of any of these circumstances, which is the main argument in our brief, that yes, within 11 days you're released and you commit another violent felony. On its face, those are terrible facts. But the context of these circumstances and his absolutely almost inevitable mental decline and all the indications in the record that he was perhaps in a moment of a psychotic episode when the second crime occurred, nothing in the record indicates that Justice Convisor was aware of any of that. She focused on the facts of the new case, meaning his actions in snatching the necklaces from the blind woman, as well as his criminal record. Nothing is mentioned about the other case or the program offer that he made.
As far as we know, he hadn't committed a violent crime for 6 years. If that was correct, that the last one was in 2011?
Correct.
Thank you, Counsel.
Thank you.
People versus Burgess.
Good afternoon, Your Honors. May it please the Court, my name is Ivan Pantoja, and I represent the appellant, Anthony Burgess. We respectfully request that this Court exercise its broad plenary power and reduce Mr. Burgess's sentence of probation from 5 years to 3 years for the following
Mr.
reasons.
Pantoja, you know, it seems to me that your client hasn't really learned the lesson, right? I mean, he was adjudicated at YO back in 1982. And since then, he has accrued 11 state convictions and 2 federal convictions. So he has also been charged with violating federal parole or probation, and 4 times has been the subject of a bench warrant, or 5 times has been the subject of a bench warrant. So why should we exercise our substantial discretion in this matter?
I would note that his state convictions, his last one was in 2014, and I believe that was for possession of marijuana.
Is
And
this his
it is-
first felony?
No, Your Honor.
How many felonies does he have, and when were they?
Well, his federal convictions are certainly serious crimes. His last one was in 1992, and he did violate probation, as Your Honors noted. But I think it's important to note that the mitigating factors here would warrant a sentence in probation. Now, the PSI, a reduction in sentence of probation, the PSI notes that Mr. Burgess was in very poor health. He suffers from diabetes, asthma, sleep apnea, 57 years old. He also suffers from hypertension. The second mitigating factor that I'd like to address is this was not a violent offense. Now, I by no means mean to minimize the seriousness of a felony drug sale. But I think it is important to note that the total amount of drugs here was less than 4 grams.
20 bags of Coke and 20 bags of Coke was less than 4 grams?
Yes, that's what the lab report noted. And 4 grams is approximately a tablespoon.
So, but let's get to the point. He was sentenced to 5 years probation. You want 3 years probation. Given his criminal history, his background, what you state are his issues, why would we reduce it to 3 years probation? Why is he not the perfect candidate for probation? Not to mention the new Less is More Act. So that if he is great, if he does well on probation, wouldn't they automatically reduce the term of probation?
No, Your Honor. Less is more applies to post-release supervision and specifically parole, not to probation. But
are they not reducing terms of probation as well based upon if they do well on probation or not?
No, that would be Your Honor's purview. And I can say that he's been on probation for 4 years.
The sentencing judge does not have the ability to lessen the term of probation if probation makes a determination that it should be lessened. Do they not make an application to the sentencing judge to do so?
Absolutely. I misunderstood your question.
Oh, I'm sorry.
Absolutely. Mr. Burgess was eligible to receive a sentence of 3 years probation. And the sentencing court, even if the Department of Probation wanted a sentence of 5, the sentencing court could have issued a sentence of 3 years probation.
And he has 1 year left on probation. Is that correct?
He does. He's had no probation violations. Although checking in with your probation officer at this point
is onerous.
It can be for someone who, for example, with the health issues that Mr. Burgess does. So my understanding is that Mr. Burgess uses a walker to walk. He has difficulty standing for more than 20 minutes. And although he's been completely compliant with probation, he has had numerous probation officers. And the reason is I believe he's considered a low priority because he's not had any probation violations.
Thank you, Mr. Pantoja. I'll give you an extra minute on rebuttals.
Understood. Thank you.
Good afternoon, and may it please the court. Molly Morgan for respondent. Defendant's probationary sentence was fair and appropriate and should not be reduced on appeal. First, I'd like to note that his criminal history does demonstrate difficulties complying with these supervisory terms. He had his parole revoked at one point, his federal parole.
I highlighted all of those at the beginning, but those were a while ago, right? I mean, he's 56 on a walker with severe illness. So he's not violating parole anytime soon, is he?
That might be true, but I don't think that he has offered any reasons to reduce his probationary term by that extra year at this point. Again, as we note in our brief, he could have received a substantially harsher punishment, and there was strong evidence of his guilt. And I would also...
Are most, if not all, of his convictions drug-related?
Yes, that's true. Quite a few are drug-related.
Okay, so you have a junkie who will do a lot of different things to get his he's fixed, right? Now he's so ill on a walker with diabetes and a lot of other conditions that pretty much make it very, very difficult to engage in his prior activity, correct?
That may be true.
Yeah, I'm just trying to figure out, like, what the purpose of incarceration is. I mean, are we protecting the community from this guy who will be probably locked up in his room or walking around in a walker?
And I think that's probably why the court determined that probation was appropriate. And again, the defendant could petition to have his probation reduced by the trial court, or the trial court could reduce it on its own accord at this point. So for all those reasons, we believe that
He already served his incarceration time, right?
he didn't receive an incarceratory sentence on this conviction, no.
I see.
I have that. Does he have any violent felonies?
Not that I am aware of, Your Honor, no.
Okay. Thank you, Counsel.
Your Honors, unless you have any other further questions, I'll just rely on my brief, and thank you for your time.
Yeah, I think we're good. Thank you, Mr. Pantoja. Thank you. MC New York? Okay, let's see. Appellants.
May it please the court, good afternoon, Your Honors. Cecilia Finelli for the appellant. Reversal of the dismissal of MNC's complaint is mandated because the lower court disregarded the stringent requirements of CPLR 3211A7 and A1, as well as misapplying the substantive principles of agency law and the personal services contract doctrine. Initially, contrary to Accor's contention, this appeal was taken from a final order and is timely. The Supreme Court failed to accept the facts in MNC's complaint as true, with one exception. The court did accept as true MNC's allegation that Accor was MNC's fiduciary agent regarding the operation of the hotel at issue. As paragraph 25 avers, the principal-agent relationship gave MNC the unconditional power to revoke Accor's agency at any time and for any reason.
That may be true, counsel. I mean, we'll concede that. But what about the contractual, what about the fact that there was also a contract involved? And there were contract obligations and duties that could expose your client to having to pay money to Accor pursuant to the contract if the termination did not happen pursuant to the contract. So in other words, you're allowed to get rid of Accor, but there might be consequences caused by the contract that you agree.
Well, I think that the law is very straightforward, that the power exists. Now, the complaint, Your Honor, has also pled the right because there's a pre-existing default. And in paragraph 21 of the complaint, for example, the pre-existing default of the HMA is pled of 3.1, 9.2, 7.12, 7.16, 7.2 small I, and 7.3c. So our position, to be very clear, is not that there can be a termination here with the power and that the case ends after that. What happens then routinely in these types of cases is the damages litigation begins. And Accor has its damage claim, and if it is found to have complied with the contract, not to have been in pre-existing default, then if it can prove damages, it can recover damages. Likewise, my client, after termination, would have its contract claim. I'll give you an example. Within the FHR decision, they cite the restatement third of agency. One of those cases is a case that I had handled 30 years ago. And at that point in time, there hadn't been much jurisprudence on this, and the notion that these were fiduciary contracts wasn't quite established. The court here has unequivocally ruled that this is a fiduciary relationship. And in that case, I represented the owner. We terminated. Hyatt brought a $100 million counterclaim. We had a very large claim. Hyatt's counterclaim, we litigated for 2 or 3 years. Hyatt's counterclaim was dismissed. Our claim ultimately proceeded to trial and was settled shortly before that. So it's very clear that what would follow this termination would be respective adjudication of damages claims. What is not...
Counsel, what I don't understand is essentially what you're saying is, well, there's a contract, there's not a contract. Isn't the right rule here that the hotel operator can't get injunctive relief? I mean, isn't that really the rule and that's the end of it?
No. The issue of the injunction is not dispositive. That's a distinction without a difference. I realize the court raises that. But
even the FHR case, what was that? That concerned injunctive relief, right?
That's correct.
So it's not analogous to our situation. There's no request for injunctive relief here, is there?
Well, this case doesn't concern an injunction, but that is not the...
Well, then how does that case apply here?
Pardon me?
How does the Southern District of Florida case even apply to our facts here?
How does the FHR case apply? Because the FHR case makes very clear that alleged waivers like 1513 and alleged preconditions like 4.3 are not enforceable.
Is there a New York case that says that? I know you got one from Florida, but which concerns injunctive relief, so it's not even clear to me that that's really relevant to its holding. Is there a New York case that supports your position?
Well, FHR is based on New York law.
That's not what I'm asking you. Is there a case in New York that supports your position that you have the unfettered right, despite a contract, to terminate, based on the straightforward principle?
I mean, FHR is a federal district court case from Florida applying New York law. Right?
That's correct.
But still, FHR's focus was mainly on preliminary injunctions, and that was the focus, not on the damages. They didn't even get to that.
But that, once again, is a distinction without a difference, the fact that it is an injunction. And in fact, what happened here is literally, if you think about it, we make this point, this is essentially what the court has done, is granted a de facto injunction, because if a hotel owner has to wait until litigation concludes, think about it, we are 3 years into this litigation and it hasn't even begun yet.
That's what you agreed to in the contract. And why shouldn't we apply straightforward contract rules to this dispute like any other commercial dispute?
Well, because the reason is that this is an agency contract. That's indisputable on this appeal because the lower court found that these are they're in a fiduciary relationship, and the agency law trumps the contract terms. That was made clear in FHR. It's made clear in the cases that FHR cites. Those contract terms are not dispositive. The law is clear that those contract terms are not controlling, even if they say the contract is not revocable.
When you talk about the law, you're talking about the Southern District, the Florida case, correct?
I'm talking about the Southern District of Florida as it applies New York law. So
at best, that would be persuasive authority, at best.
Your Honor, I'm having difficulty hearing. I'm sorry, I have a hearing loss, a temporary hearing loss in one ear.
At best, that would be persuasive authority. It's not binding on us, that decision, right? And as my colleague points out, it really concerns injunctive relief and not the issues at hand.
I don't agree with that, no. I think that it clearly cites a body of New York cases which hold that these types of alleged waivers and preconditions are not enforceable It doesn't have anything to do with whether it's injunction relief. It has to do with whether or not it can be terminated either with or without an injunction. Many of the cases that the FHR case relies upon aren't injunction cases. The one that I just described was not an injunction case. No one sought an injunction. And the termination occurred, and then the damages followed. None of these cases are restricted solely to the concept of an injunction. These principles...
Your time is up, counsel. I thought we would have spent more time trying to figure out what the triable issues are here and why the court should not have decided, basically as a matter of law, that in the context of a 3211 motion. That's what I thought you were going to focus on. Your brief spends a lot of time talking about whether a court timely commenced an action challenging the alleged default, thereby triggering 14.3.
Well, Your Honor, that's just responsive to the argument, but I agree with you completely that that is a totally fact-intensive inquiry, improper on a motion to dismiss.
Okay. Well, that's the posture in which we're in, so I thought you would focus more on that rather than some of the other issues, but you got 4 minutes coming back in rebuttal.
And I will address that. Thank you.
Okay.
May it please the court, my name is Peter Sherwin of Proskauer Rose, and I represent the respondent, defendant, Accor Management US, Inc.
Counsel, your opposing counsel says that 14.3 should be unenforceable because it's essentially like a preliminary injunction. It's essentially forcing specific performance because the trial can go on so long and they're stuck with their managers.
Not so, Your Honor. She's incorrect. This court has enforced those types of restrictions repeatedly, including the decision by Justice Acosta and Justice Singh just last year, which was East Empire Construction 283rd 1. And the second part of that answer, Your Honor, is that as FHR decided, that issue of enforcing a restriction on termination is only unenforceable in the agency context when you try to prevent somebody from terminating the agency. And the case that I would refer Your Honor to, and we cite it quite often, is the one of Wilson-Sullivan, and that's a New York Court of Appeals case. And that's the case, actually, that the Turnberry, the FHR decision in the Southern District of Florida relies upon. And that case, the New York Court of Appeals made very, very clear that these restrictions in agency agreements are enforceable and that the breach of them by a principal, here plaintiff, is wrongful and results in damages. But they said, we abolished, in the context of personal services contracts, the ability to get specific performance. And so we cannot stop somebody from terminating a personal services contract, and we're not going to. But in the next breath, the Court of Appeals said, but you're liable in contract for damages, and what you did is wrongful and a breach, just as Justice Singh recognized in his earlier questions. And so the only issue really before this court and before Justice Sherwood below, right before he retired, was what are the other ramifications of that? And this court has found...
Meaning damages, right?
In addition to damages, because we do have a damages...
Well, is that inconsistent with Wilson?
It's not inconsistent with
Wilson.
It's 100% consistent with Wilson that we have a claim, Accor has a claim for damages. But that line of cases goes on, and it includes Film Line, the United Artists, which the court, Your Honor, and Justice Singh relied upon in East Empire. And that case says that if you have breached that provision, even if you have the power to do so, because we can't force compliance, specific performance of an agency or a personal service contract, if you nonetheless breach it, not only are you open to damages, but you also can't argue in response that your termination was justified. All of that is barred by your fundamental repudiation of your contractual obligations, which here were set out both in 1513 as well as 14.3. And the other case that I would refer your honors to is the Sauer v. Xerox case.
But on the, I'm a little confused. So on the 14.3, you will still have a triable issue, right? As to whether MNC terminated the MHA pursuant to its terms, right?
No, Your Honor, we wouldn't have a trial on that, and that's because it's a 3211A1 documentary defense case. And the only two documents that are relevant to making that determination, and this was not challenged below, are the contract itself, which isn't even necessary to be called documentary evidence because on a 3211A7, you necessarily have to consider the terms of the contract. And the second document, Your Honors, is their notice of termination. And it's in the record. It's 1.5 pages long. It's a record 180.
Notice of termination, you mean the April 29th notice of termination or
No,
the
the
August?
December 17. December 17, April was the notice of default.
Notice of default.
That wasn't wrongful. That was doing exactly what they should have done, which was go through the contractual termination provisions. That was exactly the right thing to do. But
You mean the
halfway
notice of
through, they
termination that
pivoted.
came after the August letters?
Exactly right. After the August letter and after Accor then commenced litigation for a declaratory judgment that they're not in default, which again is exactly what the parties agreed the process would be, then owner threw up their hands and said, you know, I don't want to follow what I agreed to. I don't want to wait for this litigation, even though that's exactly expressly what I agreed in this contract to do. And so we said, and this is record 189, please be advised that owner, pursuant to its common law rights and powers, hereby terminates the above referenced management agreement.
That's the December 17th
That's
notice?
December 17, 2019, exactly right, Your Honor. And that alone, and there's no dispute, that's why this is a 3211A1 document. They don't dispute sending this. They embrace sending this. They even said they sent it in their complaint. There's no dispute about it, and there's no dispute about what that language is. Again, that makes it perfect 3211A1 document.
Counsel, can you just, would there be an issue of fact as to whether or not your client timely commenced an action to challenge the defaults? Would that create an issue of fact, at least with respect to the owner's case, and would be a basis to reverse what?
No, Your Honor, for two reasons.
Okay.
One, there were two bases for the repudiation. One was 14.3 that Your Honor just asked about. A separate independent one was 1513, and that they clearly—
That's the waiver of termination.
Exactly right, Your Honor. The waiver expressed, and it goes on, I would commend it to Your Honors, because multiple times getting up to that waiver in that very section, they say that this is a fundamental basis for the parties entering into the agreement. That's why it's a repudiation. It is a fundamental core breach of the whole thing. But Justice Singh, to answer your question, the second reason why is that 14.3 expressly says, sorry, I'm flipping to it. It expressly says, quote, upon initiation of legal proceedings, the non-defaulting party shall only have the right to terminate this agreement if the court has made a final non-appealable ruling. It says upon initiation of legal proofs.
Which happened on August 30th, you're saying?
Exactly right, Your Honor.
So
On
let me just,
August
if you would
30th,
bear with
2
me.
months before.
If you would bear with me a little bit here. If they had sent this letter on April 29th saying you're in default and you have to clear this default up by June 3rd, and then based on these facts, they were sent $3.2 million, but they didn't clear anything else up, according to MNC. If MNC had done nothing and just sent the termination letter then, would they have had an issue? Isn't the real fact that they sent this letter in August saying, hey, you know, you're still in default, you know, by August 30th, you need to do something, and then they respond August 30th.
The key fact, Your Honor, I submit is the December 17 notice of termination. That's the thing that was fundamentally a breach of those two provisions, and that they did undisputably.
No, I understand that.
After
if they
we
had
had
done that right, if they had done that instead of sending an August letter saying, hey, if they had just
letter wasn't
terminated
even
right
necessary. I agree with Your Honor. There is a scenario under which if they had on August 19, they had instead sent a notice of termination.
We're terminating.
Sorry, if they had done it that time, there would be a factual question, or it would be a question of contract interpretation about whether or not the safe harbor, which is a different section of 14.3, was available to a court. That's the one that Justice Sherwood did look at, but that's not the fundamental one that we say Your Honors don't even need to look at. Again, it's a contractual interpretation question. It's not a fact.
Well, does it have to be fundamental? I mean, all we need is a dispute regarding cure, right? This is a 3211
100%.
judgment, right?
It's a 100%. It's a 3211A1 or A7. There are no facts at issue in order for anything to be determined. And they have never argued that there was, including below. They try to cloak themselves within that now to try to get another bite, yet another bite at this. And it's also, by the way, not too surprising. I'll just update your.
But there's a dispute as to whether the defaults themselves were cured, right?
There was, but then they took it upon themselves. They yanked the jurisdiction away from the court system that they had agreed to give, and they took it upon themselves and said, you know, we don't care. We're not going to wait for the courts to decide. You're out of our hotel, even though you have the right to be there until 2067. This was a long-term.
That'll just go to the measure of damages, right? I mean.
Well, part of it, but it also explains.
Now with the determination was extra contractually, right?
I'm sorry, Your Honor. I think it goes to the point of why they agreed to these provisions, why they're so important, and why their decision to blatantly ignore them constitutes a repudiation that this court and the New York Court of Appeals recognizes that when you repudiate a contract, you can't sue with respect to the other side's purported non-compliance or defaults under it. That fundamental breach bars their claim.
Okay.
That's what Justice Sherwood found.
Justice Acosta, I have one other question.
Sure, go ahead.
If there was a timely notice to cure, how many days did you have to cure? They say 90 days under 14.1. What is your supposition about that?
Up to 90 days. It starts at 30 days, Your Honor. And if it can't be done within 30 days and you start to do it by that time, you have up until 90.
Okay.
I would also, though, add, Your Honor, that one of the very reasons for the 14.3 provision that you can't terminate once the other side has brought litigation is to essentially allow in this long-term relationship that was to go on until 2067 for the parties to work things out. We all are sophisticated lawyers, and especially in this area, and we know that cases settle. We know that if you give things more time, that you'll resolve it and you'll move forward and do your business together. And that's the reason behind not being able to terminate it with impunity, which is what they're trying to do, while the court process is going on. It's not a strict cure period, but it's an essentially a de facto ability for the parties to work this out. And lastly, I will say that that's the very type of provision that this court has recognized in the, not this court, I apologize, it was what the court recognized at the end, it's consumers' power, and that was the case in Sauer, which is the last of the four key cases here.
Okay. Thank you, Mr. Sherwood.
Thank you, Your Honors.
Ms. Fannelly?
I would submit that none of this discussion is appropriate on a motion to dismiss. It all involves a factual dispute over the timing or race to the courthouse that they posit under 14.3. The only facts at issue here are the facts pled in the complaint, which are that they were, a notice of default was issued and they never cured. The lower court erred in finding that the August letter was a cure extension. Nothing on that letter says that it is a cure extension. In fact, it actually says that it is not a cure. And the lower court had to accept those facts as true and did not. The problem was—
How do you respond to your adversary's repudiation argument?
About contractual repudiation?
Yes.
The cases, if you look at what they're relying on, for example, one of the cases, the Norcross case, it speaks to the issue of a supplier of energy to a public utility and the necessity of keeping that flow of energy because of the need for security, because of the consequences to the utility. That's not this case. That's not the hotel management agreement case. In this situation, what they're positing is if an owner has to endure a disloyal agent for years, that disloyal agent, and the court is required to accept our averment that this was a disloyal, defaulting agent. That must be accepted as true. All the cases that Mr. Sherwood is talking about, not talking about pre-existing defaults. Even in FHR, the owner there didn't allege a pre-existing default on the management company. Here, it's different. They are in default. My client not only had the power under this complaint, but the right. And for that reason, reversal is mandated.
Right.
Although
14.3 will determine whether, termination was proper and the circumstances under which he was, right?
I disagree with that, because certainly 14.3, as cited in the record here with the last sentence dropped off, which refers back to 14.1, which says that the outside cure period is 90 days. What the Corps is basically telling the court is, we have an unlimited cure here. We can control cure. No.
Right. They argue it specifically precludes termination of the contract within a safe harbor, right?
But nothing in 14.3 modifies 14.1, and if you look in their briefing and the court's decision, they purposely delete that last sentence. This is a 14.1 case, and I think it is absolutely crucial that you look at the notice of termination at 189 of the record, because the companion argument that they make to 14.3 when they lob off the last sentence, they characterize my client's notice of termination as just based on common law rights. That's not true. If you look at it, it says here, under the terms and provisions of 14.1 of the management agreement, they're serving this notice of termination. What this case is really about is they're trying to rewrite the hotel management agreement into the management agreement they wish they had, rather than the one that they actually signed, which had 14.
No, you made that point well in your reply brief, so.
Yeah, that is really what this case is about. And the court was required to accept our version, not migrate to a Corps complaint, and then going into a Corps complaint, they introduce 2 HMA provisions and don't provide the full provisions. 15.13 does not apply here because there's an exception, and they leave that exception out.
You have me at a Corps competing statement of facts that
Correct.
you allude to.
It should be our statement of facts for purpose of motion to dismiss.
Thank you. Thank you both. Great arguments. Okay. Zurich American. Zurich. Your time is running.
Thank you, Your Honors, and may it please the court, Patrick Coughlin for the appellant in Zurich. We ask that this court reverse the summary judgment ruling in favor of Utica, RSUI, and Scottsdale. There are a lot of issues that we address in our briefs, and we'll rely primarily on those submissions, but there are a couple of points that I do want to highlight for the court today. In dismissing the claims, in dismissing Zurich's claims against Utica and RSUI, the trial court violated several foundational tenets of policy construction in holding that a joint venture exclusion and a broadened a commercial automobile extension endorsement applied to bar coverage, and this ruling went well beyond the intended scope of the exclusionary language as contemplated by the policy. The joint venture exclusion appears within a provision entitled broadened named insured, which in turn falls within a commercial automobile extension endorsement. The gist of it is that had the named insured of Utica Rebar Steel Corporation not paid an additional premium, this endorsement would not be in the policy, and we would not be here having this discussion with Your Honors, at least on this particular issue. The trial court's first error of law was that it took the joint venture language and it read it in a vacuum, and it totally disregarded the broader context of both the broad named insured provision and the endorsement itself. The first paragraph of the broad named insured provision addresses newly formed and newly acquired entities and states that those can qualify as insureds under the Utica policy. The second paragraph, which is the language at issue here, says that no entity will be, I'm paraphrasing here, no entity, actually, pardon me, there's no reason to paraphrase.
If we accept the arguments that you're making, are we essentially striking the provision concerning joint ventures? I mean, how do we read that in conjunction with your argument?
No, Your Honor, to the contrary. In fact, our interpretation is the only one that follows the spirit and letter of New York law and policy interpretation, because to endorse the trial court's conclusions here would excise the prefatory language in the endorsement, which is a part of the endorsement, and it has to be given effect. The prefatory language states, only that insurance provided below that broadens coverage under the commercial auto coverage part applies. The trial court didn't really address this issue in detail. On appeal, Utica argues that this court should just disregard it, and it makes a number of different suppositions about why that should be the case. All of them fail. But at the end of the day, the reality is that this language forms a part of the endorsement. And it says, only the provisions within the commercial automobile extension endorsement that broaden coverage that's otherwise available under the standard coverage form can apply. Had Rebar Steel not paid an additional premium and purchased this endorsement, there would be no joint venture language in the policy at all. And so because the Zurich insureds, the two Perini entities here, didn't obtain their additional insured coverage through the broad named insured provision, to expand the joint venture exclusionary language beyond the scope of that broad named insured provision violates the prefatory clause. And where the trial court really went astray is it seized upon a non sequitur at oral argument that the specific controls the general. And that's, if you read the court's decision, that is really what it seized upon. And the problem with that doctrine is that it has no application here. The cases in New York that address that line of thinking, they involve two contradictory provisions that cannot be reconciled. The Music decision, which is cited in the opinion from the court, it involved a dispute over when the obligation to pay licensing fees.
So why do you think that's a non sequitur? I don't understand. The lower court basically found that the provision in the Utica endorsement addressing the joint venture is the one that applied, because it was, I mean, the prefatory language said only that insurance that broaden coverage apply, but the later more specific language about joint ventures control is what they found.
The problem is that those two provisions aren't irreconcilable. And this court's decision in Steadfast versus Sentinel Real Estate from 2001 says that when there is a path to reconciling seemingly contradictory provisions, the court is obligated to do so.
So more specific in general, as a rule of construction, it just requires us to harmonize it.
If it's possible under any circumstance, yes, this court's prior decisions requires that. And here, the interpretation that we set forth in our briefs does that. It harmonizes that. Utica and RSUI's position, it takes a red pen out and it crosses out the prefatory language. That's not permissible under New York law, and we think that that warrants a reversal. The trial court didn't reach the issue, but on appeal, Utica raises a question about whether or not the two Dubrini entities qualify as insureds under the Utica policy. This is flawed for several reasons, and we go into it in detail in our reply. First, we're not just dealing with the duty to indemnify here. This is also a duty to defend case. And New York law is clear that an allegation in an underlying pleading is sufficient to trigger the duty to defend. Utica acknowledges that in the underlying cases, there are third-party complaints naming both the joint venture at issue, but also Utica's named insured Rebar Steel Corporation. Under the Allstate demolition case and a number of recent cases that we highlight, that is sufficient. And Your Honor, I see my time is up. If I could just briefly finish.
I'll give you 30 seconds.
Thank you, Your Honor. The second issue in terms of insured status, it goes to joint ventures. And as we lay out in our reply brief, under the Gramercy versus Dumont case, where a joint venturer is engaged in the proper conduct of the joint venture, that is attributable to the co-venturer, and the co-venturer is bound by that. And we think that the Travelers versus Harleysville case from 2020 in New York County delves into these issues very carefully and lays out why the conduct of one joint venturer can constitute the conduct of a co-venturer, particularly when it deals to issues of accessing additional insurance coverage. With that, I'll reserve the rest of my time.
Thank you.
Thank you, Your Honor.
May it please the court, Leonard Porcelli on behalf of the respondent appellant Scottsdale Insurance Company. In addressing the appellate arguments as against Utica, Scottsdale joins in most of the arguments with Zurich. I just want to highlight a couple of points, which the most obvious being, why doesn't Utica just do a separate endorsement regarding joint ventures? Why bury it into this document that says it's an extension endorsement and uses that prefatory language that Counsel Zurich has described?
What do you make of the argument that in the Utica policy, the joint venture has to be named as a separate insured?
That has to be named as a separate insured? Yes. Again, that is the type of language that I'm saying would be appropriate in a separate endorsement. You have a list of exclusions in a policy, and then you have endorsements that exclude. And that's what a policyholder should be expected to look at. It shouldn't have this language at the beginning that says it's all broad, it's all adding.
How did, sorry, counsel, how did Scottsdale list the JV in its contract, in its insurance contract? Because the JVs are named as additional insureds, correct?
The JVs are expressly named in that.
How was that done?
There is a named endorsement provision, and they are the joint venture as well as one of the members of the joint venture are expressly named there.
Right, and that was the case with Drive New Jersey, correct?
With Drive New Jersey, yes.
And also with Endurance, correct?
I am not 100% sure about Endurance as to whether they expressly did that, but these policies are following.
Zurich
they are following form.
Counsel, okay, good. Zurich, their policy with Tudor Perini, they had a policy with Tudor Perini, right?
Tudor Perini was with the policy with Zurich.
Right.
The Zurich.
And that policy lists 76 joint ventures by name, doesn't it?
That is correct, yes. It does. But in this situation, you could have a separate endorsement that makes this clear to a policyholder that they're losing coverage here, that they paid an endorsement for this, and it was taken away.
Thank you, Counsel.
Thank you.
2 minutes go fast.
Good afternoon. My name is Jonathan Glasser. I'm from Lester Schwab, Katz & Dwyer, and we represent Respondent Utica National Insurance Company of Texas. May it please the Court. The motion court granted Utica's summary judgment and declared that Zurich's insureds are not insureds on the Utica policy issued to Rebar Steel Corporation. We respectfully request that this court affirm that ruling. Utica issued a commercial auto policy that lists one named insured, Rebar Steel Corporation. And the declarations of the policy limit coverage to one business form, corporations. In keeping with that, Utica issued an endorsement entitled the Commercial Auto Extension Endorsement. And that endorsement further states that no person is an insured for the conduct of a joint venture, a current or past joint venture, unless they are listed in the declarations. Here, the underlying action was brought by an injured employee of the joint venture. And that joint venture...
And that was, I'm sorry, that was the basis of the fact that they were not listed in the Utica policy is the basis for the denial that you issue, right?
That's correct, Judge Acosta. The joint venture entered into a contract with Tudor Perini, again, the joint venture, to supply rebar for construction at Hudson Yards. The joint venture loaded the rebar on a flatbed trailer owned by Tudor Perini, connected to a power unit leased by Tudor Perini, driven by Tudor Perini's employee, Michael Labozza, who then drove the truck to Hudson Yards for unloading. When he got there, he parked on an uneven surface, then unstrapped the load, which this court found directly caused it to fall onto Kevin Quinn, the joint venture employee, who was placing straps on the rebar at the time so that it could be lifted by a crane. In sum, to the extent that Tudor Perini and legacy owner, who are the Zurich insureds here, claim that they're liable for another's conduct and not their own, it's the conduct of the joint venture which brings the facts of this case squarely within the joint venture provision of the Utica policy.
So Utica refers us to the prefatory language. Now, if we agree with your interpretation, are we excising that language? Because obviously we have to give that language meaning too, right?
That language has a different purpose than the one that's proposed by Zurich in this case. The language says only that insurance provided below that broadens coverage under the commercial auto coverage part applies. What it's actually explaining to the insured is that the policy contains limiting language, but the limits, I'm sorry, bear with me 1 second, that the broadening provisions to the insurance are only under the commercial auto coverage part. It's just a limitation of the broadening aspects of the policy to that commercial auto coverage part.
And if we were to agree with Utica's argument, what effect would that have on the joint venture provision?
It would have no impact on the joint venture provision because the joint venture provision is not a broadening of coverage, it reduces coverage. And that was the intent of it. When Utica issued the policy, it had an ISO coverage form that it used, which didn't address joint ventures at all. And so as part of its desire to limit its exposure to potentially unlimited damages for the conduct of a joint venturer that Utica knows nothing about, it inserted language like this into an extension endorsement. And the goal is to prevent this unlimited exposure to Utica without any opportunity to underwrite the risk because the joint venture was not disclosed. Now, one of the Zurich insureds are not entitled to coverage under the Utica policy, but this outcome does not leave them uninsured. In addition to Tudor Perini's own insurance policies, B&R Rebar's policies with Drive New Jersey, Scottsdale, and Endurance cover the joint venture and also list the Zurich insureds as additional insureds. These policies collectively provide the exact amount of insurance required under the contract between the joint venture and Tudor Perini.
But isn't the question whose pocket, which insurance company's pocket the money's coming out of? I mean, isn't that what this litigation is about?
Yes, that's exactly what this litigation is about. But the intent of the parties was that the pocket that should be paying would be the pocket that the joint venture, BNR, purchased coverage from. Unlike the other partner who purchased a policy that provided no coverage for joint ventures. It's completely rational that if you have a joint venture, that one of the joint ventures would purchase insurance for that joint venture to cover both of their exposures. And that's exactly what happened here. It would be, in fact, irrational to have both of them purchase the same insurance. Finally, appellants' briefs requested only a declaration that they're entitled to a defense in this case, but they are already receiving a defense from Drive New Jersey, who paid their past defense costs and are defending going forward.
Okay. Thank you, Counsel. Okay, you get 3 minutes.
May it please the Court, John Favati, Hardin, Cunliffe, McKeon, and Paletto on behalf of Respondent RSUI Indemnity Company. Your Honor, the Court should affirm the trial court's order dismissing all claims as to RSUI for 2 reasons. RSUI issued a true excess policy that affords no coverage for the conduct of any joint venture, including the joint ventures whose conduct is at issue in the underlying case. And 2, there's no contractual requirement in the trade contract for excess commercial auto insurance to apply primary to all other insurance. And for those reasons, there is, the trial court correctly ruled that the RSUI policy is inapplicable to the claims at issue in this case. Focusing on the language of the Utica policy, which my client's policy follows Form 2, the question arises as to whether or not the prefatory language can be harmonized with what's been referred to as the joint venture language. And it can be harmonized. The prefatory language speaks to coverage provided by the policy. The joint venture provision is not coverage provided by the policy. It speaks to who can access the coverage provided by the policy. And just to conclude, given that my time is running, we've addressed the points in our brief, and I would emphasize that my client's policy is a true excess policy. There's no contractual requirement for it to apply prior to any of the underlying policies, and therefore, the order as it relates to RSUI should be affirmed in all respects. And unless the courts have any questions?
No, we're good. Thank you.
Thank you, Your Honor.
Okay, and now let's get rebuttal. No, they all gone. Rebuttal is left for Zurich. Unless you want to waive it. Okay.
Thank you, Your Honors. Just a couple points to briefly hit on. First, to the question of other policy forms that contain joint venture language. Both in Utica's citations to the record, including the Zurich policy, also its case law citations. Those are cases that involve joint venture exclusionary language within a standard CGL coverage form. So they don't appear within a commercial auto extension endorsement, and critically, they're not constrained by a prefatory language that says that only broadening provisions can apply. So those are really apples and oranges. They just don't relate at all. They have no bearing. And respectfully, neither Utica nor RSUI can come up with a credible narrative for how to reconcile the prefatory language with the joint venture exclusion.
Well, counsel for RSUI did make an argument as to how to reconcile it. Why is that argument weak?
It's weak because it doesn't address what the language actually says. I'm not to paraphrase counsel, but it says something like, well, that addresses the policy and how it applies. We just ask that the court apply the language as it's written. And And it says only those provisions that provided below that broaden coverage under the commercial auto coverage part apply. To apply the joint venture exclusion here would narrow coverage. Therefore, it can't apply. The last point I'd like to make is my colleague from Utica says a lot about, well, it's rational that it would be this, that the parties would look to the Drive New Jersey policy. See, my time is up. Can I just briefly
I'll give you
conclude?
30 seconds.
Thank you, Your Honor. It's rational that the parties would contemplate this in the underlying contracts. It makes sense that they would try to steer coverage. The purpose of having clear insurance language, particularly in a manuscript policy that Utica drafted, is so the court doesn't have to go down these rabbit holes about trying to figure out what might have been rational or what the parties were thinking. The parties were thinking by what's on the paper.
Okay.
We don't think that there's a way to reconcile the provisions here without reversing, so we respectfully ask that the court reverse.
Thank you. Thank you all. Marie Holding. Go ahead, counsel.
Good afternoon. Shannon McKinley may it please the court, Shannon McKinley for the defendant appellants, Bicklin Corp., Lynn O'Connor, Wilfred O'Connor, and Clyde O'Connor. We're asking that this court vacate the trial court's order and approve and confirm referee Hewitt's report.
Tell me, on your motion to renew, what was the new evidence that you didn't have available to you before?
So the new evidence is the Attorney General's assurance of discontinuance against Anthony Galatafore, who was the broker on this loan. So in 2018, January 26th of 2018, the New York Attorney General entered an order against Anthony Galatafore and specifically found that he was illegally brokering loans without a license. And as a result of that order, in April...
And you didn't know that?
No, there was no way to know. It was only entered in January of 2018. So there was no way to know that Anthony Galatafore was acting illegally.
Isn't that public record? In other words, the licensing or not of someone who purports to be a broker is public record, correct?
So licensing is public record, but previously it was believed that Galatafore was my client's broker. That's how it was presented.
No, but you know, the court have found that Gubitosi and Gallo were known by defendant, right, by your clients. Since Gubitosi, is it? He testified in his depositions back in 2013 that Gallo was a broker on the deal. That he had worked with Gallo before on various deals and knew his company, AJG.
But he testified that he was my client's broker, not that Gallo was the undisclosed.
He testified that he was a broker. So if somebody tells me you're a broker, the first thing that I would do is I go check whether you're licensed or not.
So if he was my client's agent, then my clients can claim that the fee was illegal, but that he was not my client's agent. And that is the important new evidence
So
here.
only agency creates the obligation for you to see what is there to be seen, namely whether this person is licensed or not?
No, what I'm saying is that the agency issue creates the fact that he was the undisclosed, which the referee heard 9 days of testimony, and he found that it was undisclosed to my clients that Gallo was operating as Gubitosi's agent, and that was not known when summary judgment was filed. And that's what's important here. The fact that he was working as the lender's agent renders the loan usurious, because when you add back in the
The
We
issue
already-
of usuriousness is something that we decide. I mean, we've seen, this case has been here before, has it not?
So
And whether it was, it violated usury laws or not, we've decided. So why are we going over this again?
So specifically, in your appellate decision, which is page 1628 of the record, the court held that it did not hold that the lender points are not part of usury. What this court stated was that once the points, broker and lender's fees paid to the plaintiff were reduced by the broker's share of those points, the effective rate of interest was under 25%. And so
And what does that mean? What is the significance of the 25%? That's a usury line,
that's a
right?
usury. And
So it's not usurious.
no, because you deducted the broker's fee.
Isn't that a good thing, given that you're saying that the broker didn't have a license and everything else? So wouldn't you have to?
No, that's the way the usury calculation is done, is when you add the broker fee was, in the court's prior decision, the broker fee was omitted from the calculation. When you add back in the broker fee.
Did you move to renew? Basically, you're saying that the usury calculation is flawed.
I'm saying that the usury calculation is flawed because Gallo was determined to be the undisclosed agent of Gubitosi, and because he was working for Gubitosi, therefore Gubitosi and Marie Holdings can't claim that.
But you knew that relationship back in 2013.
We did not know. I mean, that's specifically what referee Hewitt found in.
But you could have known it because it was public since 2009.
We could not have known that Gallo was an undisclosed agent of Gubitosi. That's what we could not have known, and that's the referee heard testimony.
I still don't know how that then turns this into a usurious loan.
So if the usury calculation.
I don't want to.
Yeah, I think we've heard enough on that issue.
Good afternoon. May it please the court. Scott Kreppen with David Spellman Barrett for the respondent, Marie Holdings, Inc. I will try to be brief. There are three huge hurdles to this motion, and the lower court's decision should be affirmed. First, these arguments were waived. Title was transferred subject to a third party, subject to this mortgage, and the borrower, in doing that, even though they now claim that it was a fraudulent transfer, they waived their usury argument. The inquiry should have ended there. Going past that, if we get to the motion to renew, they need new evidence, and as the court just pointed out, this is all public record. The argument that Mr. Gallo was Mr. Gubitosi's agent is a factual question. Counsel has only offered and only ever offered conclusions. They haven't pointed to any facts to support that, and even after having a 9-day hearing on a dismissed affirmative defense, they still have no facts to support that argument. It's the same exact argument that was before this court in 2016, and that decision should stand. If we were to get further and find that they actually had new evidence, and they had a reasonable excuse for not presenting that evidence, then we have to look at the usury calculation. This is a fee to Mr. Galatifori that was actually paid. It's not a subterfuge, it's not compensation to the lender, which is what would be required. It's a fee that was actually paid to a third party. And to get there, that's where the inquiry ended, because we have a check showing that he actually paid an expense of the loan. But part of their usury argument also involves reducing the principal amount in disregarding what the general obligation law says. This is a $750,000 loan. Usury is about the intent of the lender in making the loan, whether they intended to charge a usurious rate. And when he made this loan, this was a $750,000 loan at 15%.
Okay, if you were to put the Gallo's broker fees into that calculation, what would the loan then be usurious?
No, there is no way at the inception of this loan, unless
my calculations show it would come to about 24%. Am I correct about that?
If he were to take all of the interest on $750,000, meaning another $112,000, if he had done that, which he didn't, if he took that at the table, it would get you to 24%. But instead, he didn't charge interest on the full $750. He only charged it as it was drawn. So if we were to add it back in, if we were to add in Gallo's fee, we're looking at 22.34% as the effective interest rate under the band realty formula, because we have to use $750. That's the amount of the loan.
I don't know why we're talking about usury. I thought I was in the panel when we decided the issue. Did I just dream that?
We're talking
that
about...
was a nightmare that I had?
Our position is we don't know why we're talking about usury either. We agree with you, Your Honor.
So let's end it there then.
In any case, 24 is less than 25. I think 25 is a threshold for usury.
Exactly. Thank you.
Thank you, counsel.
If I may, briefly. So to address several of counsel's points, regarding the argument that the usury calculation should be based on the $750,000 principal amount, during Thomas Gubitosi's deposition in 2013, and then repeatedly through the course of the 9-day trial testimony, he testified that there wasn't, when the loan was written, there wasn't enough equity to give a $750,000 loan. So he never intended to give that $750,000 loan. The usury calculation is properly done on the amount that was actually lent, and that calculation is set forth.
Does the general obligations law get in the way of that, however? Section 5-501B says that loan advance in installments is a single loan. How do you get around that?
So I think that under band realty, I think you can get around that, and I think when this court originally heard the usury decision, the calculation was being based on the amount, like this issue wasn't decided at that juncture, and at all points.
I don't understand that. The issue was presented to the court, right? And we decided it.
You decided that based on the fact that the lender and the broker fees were, the fact that the broker fee was paid out to someone else, which was the broker check was produced in the reply to summary judgment. The court's decision was this loan is not usurious. The new evidence was the ruling by the New York Attorney General saying this person is illegally brokering loans. And
but what I don't understand is, what's unclear to me is why you continue to advance the argument that Gallo was an unlicensed broker when hearing from your response to Justice Singh's question, even if the fee were included, the loan would not be usurious. It would go to 24%, right?
no, it's my position that the calculation brings the loan, the loan is based on 31%. And I think that this loan, as testified by the plaintiff, he only intended to loan the amount that he dispersed at closing because there wasn't enough equity.
Essentially, counsel, it sounds like you're looking for just a redo of the entire, of everything and on issues that have already been decided. I mean, those are things that should have been raised years and years ago, right?
So, respectfully, I think that the issuance of the new decision said, or excuse me, the decision from the Attorney General showed that Gallo was illegally brokering loans. And Justice McMahon, as a result of that, said it's only relevant if you can prove a relationship between Gubitosi and Gallo. And that's what the 9-day testimony did. And it's our position that because that relationship is...
But in 2013, there was evidence of that relationship between Gallo and Gubitosi.
No, I mean, that's Referee Hewitt's, after listening to 9 days of testimony.
Well, with all due respect to him, to the referee, the Gubitosis testified differently in 2013. But let's not belabor the point. Thank you both for argument. Last is Gallo, I'm sorry, Gunn versus Hamilton.
Good afternoon. May it please the court. My name is Jordan Masseri from Kraus, Shackness, Tallentire, and Masseri. I represent the petitioner appellant Kelly Gunn in this consolidated appeal of 3 orders entered by Judge Frank Nervo. The 3 orders appealed from demonstrate multiple abuses of discretion.
So was this criminal contempt or civil contempt?
He stated it was criminal contempt on the record.
The judge himself said that on the record, right?
That is correct.
What is the implication of that, of criminal contempt?
Well, the implication was that she was found to be willfully in contempt.
Well, when you say she was found, was there a hearing?
There was no hearing.
Right, so a criminal defendant has certain rights, right?
Well, Your Honor, that's my...
Including meaningful representation.
Well, Your Honor, that's part of my point, yes. She was entitled to meaningful...
I just want to cut to the chase. It's late in the day, so...
Understood, Your Honor. As far as the contempt motion is, as far as the contempt finding is concerned, it was totally improper. An adjournment was admittedly reasonable by the judge, but at the same time, he granted an adjournment while making a finding of contempt without a hearing. But that's not really what I want to concentrate up here on, with all due respect. The underlying counsel fee order is really what is the more important issue. As if the counsel fee order is vacated, then I don't believe we even get to contempt, which becomes...
So was that an interim order or a final order?
So Your Honor, you may recall that this court previously, as a matter of first impression, this court already addressed and affirmed an award of interim fees that were deemed necessary as a matter of equity to enable respondent to defend the application. But that was an interim decision. And specifically, part of that affirmation stated and agreed that part of the holding, which was for additional fees and past fees, would be held in abeyance. I believe the trial court's actual language was pending a hearing framed on that issue. That's part of it.
So there hasn't been a hearing on the reasonableness of the fee?
There was no hearing on the reasonable of the fee, and there was no consideration of a lot of other things that needed to be considered by the judge before issuing what was this second fee order. But more importantly, it's now a matter of first impression again, because appellant has now definitively been adjudicated not to be a legal parent within the context of the domestic relations law. Previously, the interim order said, without reaching whether she is a parent or not, we find it would be inequitable under these circumstances not to allow an award of interim fees. Well, now we have a person who is definitively adjudicated not a parent, possibly being subject to a statute that, by its plain terms, does not subject non-spouses and non-parents to its terms.
But then what was the whole point, going back to the original decision of giving your client a right to try to establish parent by estoppel? It really arises out of the domestic relations law, doesn't it? I mean, so maybe your point is well taken. Going forward, no more attorney's fees, but we have concededly a lot of attorney's fees spent by both sides, and there is a fee-shifting provision.
I'm sorry,
And there is a fee-shifting provision, right?
Yes, Your Honor, there is a fee-shifting provision, but I'd like to call your attention to an important point, which is that an award in this instance, which would affect mostly same-sex or LGBTQ couples, would be wholly consistent with the current law and filiation proceedings that overwhelmingly affects heterosexual couples and other similar proceedings, like in grandparents' rights. There's no fees awardable when it comes to grandparents' rights. Moreover, in the interim decision on that original interim fee order, this court said specifically that its award would be made to enable respondent to defend the application as a matter of equity. to enable the respondent to defend the application. Respondents won. This case is over. This case has been over for a year and a half.
But she won subsequent to the entering of the interim order, right?
Well, Your Honor, that's a good point. We call it an interim order, but it's not an interim
Well,
order.
that's why I asked you the question initially. Was it interim, was it final?
It's not in the nature of an interim order because it awarded fees retroactive to the beginning of the case. That's not what an interim order is supposed to do. An interim order is supposed to be prospective, not retroactive, and that was the whole point of holding the other part of the question on this court's initial decision in abeyance. That was part of the whole point, is to now address it, now that we know whether appellant is considered a parent or not a parent under the meaning of the domestic relations law.
Okay, all right.
But, sorry, one more point?
Quickly, please.
The award is not necessary to enable respondent to defend the application. Originally, the interim order was made based on her need. She's already won. She had counsel throughout the matter, and the case is over, and it's been over for more than a year and a half. As such, what we're requesting is that this case be adjudicated as complete, final, that the orders be vacated, and that it be considered over.
Okay, thank you, counsel.
May it please the court, Gretchen Beal-Schuman for respondent Cersei Hamilton. Your Honor, this case has indeed been adjudicated to the final stopping place in terms of the merits of the matter. Justice Nervo was very clear in a poignant decision that was 38 pages regarding the various facts and procedural turns which has gotten us to this place.
We have a criminal contempt finding where there was no hearing. What about due process?
Your Honor, I don't
know
actually...
that there was no hearing on the attorney's fees either.
Actually,
where are the hearings?
I would like to address that, Your Honor, and I'll address both points in order. First, with regard to the contempt application, there was actually no written opposition served by Ms. Gunn to the contempt application.
She asked for an adjournment, which was granted.
The adjournment was granted, and in fact...
So why would there be a need to file opposition papers? I'm assuming she needed an adjournment because she needed counsel.
Well, in fact, Your Honor, in the transcript, Justice Nervo says, I will grant the adjournment, I will also grant the contempt order, and I will stay the contempt order. And in the meantime, Ms. Gunn can make whatever applications that she wants.
Can you enter a contempt order in the absence of representation?
Your Honor, I don't believe there was an absence of representation here.
Well, how about the absence of a hearing?
Your Honor, first of all, the contempt application went unopposed. And
unopposed by whom?
By Ms. Gunn.
She didn't have an attorney. Did she actually have the ability, since she does not have an attorney and she's requesting an adjournment at that point in time, to oppose the contempt order? Does she even actually know what that means? I mean, she's not represented.
Well, Your Honor, actually she was represented, and Justice Nervo found specifically that Ms. Gunn was represented and that Warshaw Burstein...
Oh, no, I disagree with that. I mean, he could have found whatever he wanted, but the fact is, counsel was clear that he was there as a courtesy.
Right.
Right? Isn't that what he said?
That is what counsel said. That is not what Justice
Nervo...
Nervo...
He's there as a courtesy. I'm not representing her. She needs counsel. She makes the application. She's given the 60 days, but nevertheless, a contempt finding, that 60 days is made contingent on what? I mean, what was the reason to retain counsel when there was already an adjudication of contempt, of criminal contempt?
Well, Your Honor, specifically, the criminal contempt order was not made in a vacuum in this case. This matter has been pending a very long time.
I'm not going to defend the contempt finding. What I will defend is the process by which criminal contempt was found.
Your Honor,
when you adjudicate someone in criminal contempt, there are certain rights that inure to that criminal defendant.
Your Honor, I'd like to point out in our opposition, in our respondent's brief, actually, we addressed this specific point. In fact, we don't believe, even though Justice Nervo used the word criminal contempt, that he was exercising his powers of criminal contempt. He was exercising his powers of civil contempt, which is what
So
happens.
he didn't mean what he said.
It's not that he didn't mean what he
By
said.
criminal, he said he meant civil.
I
By
think-
civil, he meant criminal.
I think the reference was an error. I think the ultimate result was an exercise of the civil contempt
Well,
powers.
did you go to Justice Nervo and say, Judge, excuse me, there's an issue here, it's not criminal contempt, it's civil, anything like that, to clarify what was occurring?
No, we did not. But, Your Honor, the actual written order was issued subsequent to the argument on December 1st, 2021, and the actual written order is very reflective of what happens with an issuance of a civil contempt order, for example, when you have child support arrears, when you have counsel fee arrears in a matrimonial matter, when you have spousal support arrears. In fact, there's a difference between civil and criminal contempt.
Counsel, I think we're all aware of that. I think we've we know that, and that's the issue. And the issue again is the judge specifically stated criminal contempt and not civil contempt. But what your adversary stated, how do you respond to that argument? The case is over. Why are we prolonging this?
Your Honor, we're not prolonging, but RSAP is entitled to their fees. CRSS is entitled to the fees. In fact, the case has been resolved on the merits, and what Justice Nervo did was to sever the issue of the counsel fees, and there will be a hearing on the finality of those. That you're absolutely correct, Your Honor, that it was an interim order that was made. This court, in fact, authorized...
How do you have an interim order that is that reverts back to everything that goes back to everything that has been already done?
Well, I want to clarify. First of all, there's an inaccuracy in what Appellant is arguing regarding covering everything. In fact, my firm had requested, I think, in the realm of $2 million. In fact, we were awarded 1.66, so we were not awarded everything.
I thought the criminal contempt order fined her $2,700,458.09.
Correct, because that was inclusive of the additional award for the amounts that our client had already paid, as well as the interest that was running on various different judgments at that period of time, Your Honor. That's why the total was different.
Spend any of those 60 days in jail?
She did not, Your Honor. In fact, she made an application to this court to stay the contempt order, and this court granted that stay, and that's what happened ultimately. But I want to be very, very clear that the litigation strategy has been to avoid the lower court in terms of addressing the finality and addressing the fees. In fact, as part of this court's record, you could take judicial notice of the arguments on the stay application. And in fact, when Ms. Gunn appeared in February of 2022 before Justice Nervo and was asked very directly where she resides, she refused to disclose that to the court. And Justice Nervo tried several times.
As I said earlier, I'm not here to defend the underlying conduct in this case, the litigiousness involved, the acrimony in this case. I'm here to defend the finding of criminal contempt and the law. And the law is clear what needs to happen when you find someone in contempt. And the law is clear with respect to what you need to do when you, in effect, label something an interim order when in fact it's almost a final order at the end of the litigation.
Your Honor, if I may have a moment to address that, and I wanted to answer Judge Weber's question with regard to the issue of retroactive fees. Absolutely, and it happens all the time that applications can be made at any point during a family law-related proceeding under DRL 237 for fees during the action, including interim fees. There's now a rebuttable presumption that fees will be paid ongoing during the proceedings to allow the playing field to be leveled and so that the non-moneyed party is not victimized by the process and by the heavier weight of the person with the bigger purse. So absolutely, the court has repeatedly made interim counsel fee awards that deal with what's been incurred, because that's part of the process. You don't make an award, you don't make an application every day, and also then for a prospective portion, usually. But both parts are considered. 237 says interim counsel fees. 237 says to allow to bring the proceeding or defend. It doesn't say only at certain points of the case and going forward from there. The statute is very clear. The case law is very clear.
Got it, counsel.
Thank you for your time, Your Honors.
Thank you.
Also, Justice Acosta, I have one question.
Go ahead.
Sorry.
No, it's fine.
Judge Nervo is going to have a hearing on attorney's fees, right?
Yes, he is.
Does that mean he gets to revisit the interim order? And
Absolutely, and in fact, he said it's subject to modification and reallocation.
Okay.
Thank you.
Thank you.
Thank you.
I'd like to quickly address that last question. With regard to both the fee order and the contempt order, it's really difficult to imagine the chaos that would ensue if judges were routinely granted the power to prejudge applications and then only later schedule a hearing wherein the burden has been shifted to the other party to disprove what the judge already prejudged. And in this case, only after the loser has been held in criminal contempt and ordered incarcerated for non-payment of the prejudgment. That is not how the law works. And we should thank our founding fathers and the rule of law for that.
I'm sorry, did he ever lift the contempt? Did he not lift it?
I'm sorry, Your Honor?
Did he not lift the criminal contempt?
It was stayed.
We stated.
We stayed
Yes,
it.
Your Honor, you stated.
But interim orders are issued all the time. I mean, counsel is right in that respect. They're usually not contingent on findings of contempt and, applications, to be represented by counsel. I agree with you. That's not how things work. I hope you've heard from the questions how the court feels. We don't need to belabor the points, right?
I've heard a lot. Yes, I've heard a lot, Your Honor. And I just want to make one more point, is that DRL 237B is not meant to punish a litigant for engaging in litigation. And that's exactly what it's being used for here. In fact, in this case...
But wait a minute. It's attempting to balancing the interests of the person with more money and the person with less money. Isn't that all that's occurring?
Well, no, Your Honor. We don't believe that's so. Because from the outset of this case, Respondent's counsel knew that Respondent could not afford to spend $3 million on her legal fees. Yet...
Well, that's debatable. I don't want to relitigate the issue. So that's debatable. At least they contended.
But there are cases that show that the playing field is leveled when you have an attorney who is not looking to collect against their own client. In this instance, I don't think it's even disputed.
Yeah. You made that point well in your brief, counsel.
Okay. Thank you.
Thank you.
Thank you, Your Honors. I appreciate your time.